Welcome to meeting number 102 of the House of Commons Standing Committee on Health. And happy Valentine's Day to everyone. This is a wonderful way to spend Valentine's evening. I'm feeling the love here already. Today's meeting is taking place in a hybrid format pursuant to the standing orders. With respect to the folks that are participating virtually, you have interpretation available to you. You have the choice on the bottom of your screen of either Floor, English, or French. Please don't take any screenshots or photos of your screen during the meeting. In accordance with the routine motion, I'm informing the committee that all remote participants except one have completed the required connection tests in advance of the meeting. We will test Ms. Long if necessary when we get to her. This is the subject matter of the meeting is a subject matter study of Bill C-62 pursuant to the order of reference of Tuesday, February 13th, 2024. The committee is beginning its study of the subject matter of Bill C-62, an act to amend the Criminal Code, Medical Assistance in Dying, number 2. I'd like to welcome our first panel of witnesses appearing as individuals. We have Dr. Pierre Gagnon, psychiatre par videoconférence, Dr. K. Sunu Gained, Professor of Psychiatry, Faculty of Medicine, University of Toronto, is here with us in person. Representing
the Association québécoise pour le droit de mourir dans la dignité, we have Dr. Georges L'Espérance, the President, by video conference.
Dying with Dignity Canada is with us also virtually, represented by their CEO, Helen Long. Thank you all for taking the time to appear today. As was explained, you each will have 5 minutes for your opening statement. On va commencer avec Dr. Gagnon pour 5 minutes. Bienvenue au comité. À vous la parole.
Welcome to the committee, Dr. Gagnon. You have the floor for 5 minutes. Yes, good evening. Good evening, gentlemen, MPs. It's a pleasure for me to share some thoughts on this bill. First, as a psychiatrist, as a Quebec psychiatrist, I can say that a number of documents have been shared, or actually these were sort of rumors to the effect that the psychiatric community of Quebec was largely in favor of this extension of the eligibility, but this is incorrect, or that the use of euthanasia for psychiatry patients would be accepted easily, which as well is incorrect. To summarize in a few points what I would like to share this evening, we should recognize, first and foremost, that suicidal ideation is intrinsic to severe psychiatric disorders. It's therefore impossible on clinical basis, simply by interviewing or evaluating a patient, even for an excellent psychiatrist, to differentiate suicidal ideation from what we might consider to be an authentic request for euthanasia for MAID. Moreover, all illnesses have their special characteristics, and we can't apply one set of criteria to them all. Psychiatric disorders are often characterized by a wish not to live. The desire to wish or to die is a fluid wish and state. Many studies show this. Patients eventually do adapt to their illnesses and wish to live against all expectations. So discrimination and non-discrimination regarding those with psychiatric disorders involves offering each one an appropriate treatment, not offering a blanket treatment to all of them or by illness. So the very principle of equity, to my mind, is closely linked to the ability to tailor treatment to the individual. the irremediable nature of the situation of the illness is not really a criteria in mental illness is not as present, given that their suffering is irremediable by nature. So also refusal to accept treatment is often seen in mental illness. Of course, there used to be court decisions to force patients to accept medication because they lose their capacity to make wise judgments in this matter. So having a doctor decide that they should or shouldn't die when science is moving forward, showing us that these patients can be treated, that their lives can be improved, and that they can live well, would be an error. Moreover, when it comes to treating mental disorders, the relationship, the patient, the doctor, and the attitude of those helping the patient can play an important role. The duty of psychiatrists and other health professionals remains to support hope. It's a very important ingredient in the treatment of the mentally ill. Those presenting strong arguments for MAID in those whose primary condition is a mental illness, whose sole medical condition is a mental illness, often use the example of very severe medical situations of mental illnesses that cannot be treated. But studies published on cohorts of patients who have received euthanasia in countries such as Belgium or the Netherlands do show that more common and treatable illnesses were affecting patients who had received MAID. A study in JAMA Psychiatry showed that in 50% of cases, depression was the principal psychiatric diagnosis. Most patients who had received euthanasia had a personality issue or were isolated, socially isolated, and 69% were women, often for suicide. Most of them are men. Another study in Belgian patients with mental disorders asking for MAID showed that they were highly isolated and they had an idiosyncratic idea of their intolerable suffering, and that the psychiatric diagnosis itself explained a good deal of this perception, and that there were social, economic, and existential issues such as the loss of a loved one, a friend, a pet, financial issues, or simply the impression that they were a weight upon the shoulders of their loved ones or of society. These were factors rather than simply the medical condition itself being the sole factor. Let me stop here and I'll be ready to answer your questions. Thank you very much, Dr. Gagnon.
You have the floor for the next 5 minutes.
Thank you, Mr. Chair. My name's Sonu Gant. I'm a psychiatrist, professor, and governor at the University of Toronto, chief of psychiatry at Sunnybrook, a past president of the Canadian and Ontario Psychiatric Associations, and now president of the new Society of Canadian Psychiatry. I'm not a conscientious objector and was physician chair of my previous hospital's MAID team. My roles inform my expertise, but I'm here as an individual, not representing any group. I want to first express appreciation for the decision to pause the planned expansion of MAID for mental illness. In all honesty, this was the only responsible choice to make because there remain 3 critical unresolved issues. First, MAID is for irremediable medical conditions, ones that can be predicted to not improve. Worldwide evidence shows we cannot predict irremediability in cases of mental illness, meaning the primary safeguard underpinning MAID is already bypassed, with evidence showing such predictions are wrong over half the time. Second, scientific evidence shows we cannot distinguish suicidality caused by mental illness from motivations, leading to psychiatric MAID requests, with overlapping characteristics suggesting there may be no distinction to make. Combining these inconvenient truths with the fact that those with mental illness have higher rates of social suffering, like homelessness and poverty, means that MAID assessors would be wrong most of the time when predicting irremediability, would wrongly believe they are filtering out suicidality, and would instead be providing death this March to marginalized suicidal Canadians struggling with social distress who could have improved. People talk of false hope. This would be assessors colluding with the patient's mental illness symptoms and providing false despair, wrongly reinforcing that their situation is hopeless to the most marginalized who could have gotten better. That would be the ultimate discrimination. How did we get here? Twice being at the brink of providing MAID for mental illness and twice saying we are not ready? I think it's because those entrusted to provide evidence as experts have pushed ideology instead. Senator Couture's sunset clause in 2021 never asked if we could responsibly provide MAID for mental illness. It set an agenda predetermining that we would. The CAMAP mental illness module claims to train assessors to weed out suicidality from psychiatric MAID requests, yet it does nothing of the sort, and there is no evidence that we can actually do that. The expert panel tasked with providing safeguards refused to recommend any additional legislative safeguards, despite Canada lacking a due care requirement before providing death by MAID. 1/6 of that panel resigned, yet the panel chair doubled down on pushing expansion, testifying she is not concerned by the 2-to-1 gender gap of more women than men getting psychiatric MAID where it is allowed. Remarkable. And now the dissenting senators, unhappy with the pause to expand, aim to convince the Senate to disregard Bill C-62's call to pause, with Senator Couture saying they need to, quote, protect against tyranny of the majority. Wow. While citing their historic medical credentials and claiming they are addressing medical and procedural issues of the report, the dissenting senators neglect providing any evidence addressing key medical issues of inability to predict irremediability, inability to filter out suicidality, and risks to marginalized when providing MAID for mental illness. We're an outlier amongst peer nations in not even having a national suicide prevention strategy, and these dissenting senators are pushing easier death for mental illness. With any due respect to the dissenting senators, zealotry should not trump reality. I'm confident this committee, and I hope the rest of the Senate, will not follow the dissenting senators in their march against evidence. I must point out the impact expansionist activism has already had. After C7's expansion of MAID for any disability in 2021, MAID deaths shot up by 30% to over 13,000 Canadians in 2022. 2023 will no doubt be higher. Of these tens of thousands of Canadians, over 1/3 cite feeling a burden as suffering leading to MAID, nearly 1/5 loneliness, and over half loss of dignity. The debate about providing earlier, easier death has sucked all the oxygen out of the room. But what are we now providing death for? As I wrote in the Toronto Star recently, I hope this focuses us on the real issues of our fellow Canadians suffering and propels us somewhere better than pushing death to solve life suffering. If we're serious about addressing these issues, to quote that piece, Canada has a chance to be a forerunner in the world by, instead of striving to be number one globally in assisted suicide, establishing the world's first portfolio for a Minister for Living with Dignity. Thank you again for your thoughtful review of this issue. Happy to answer any questions.
Thank you, Dr. Gain. Dr.
And now we will hear Dr. Espérance from the Association québécoise pour le droit de mourir dans la dignité. Welcome to the committee. You have the floor. Thank you, Chair. Members, MPs of the Standing Committee on Health, the Association québécoise pour le droit de mourir dans la dignité thanks you for the invitation to speak to you. I'm a retired neurosurgeon and active provider of medical aid in dying. I'm also the president of our association. Regarding C-62, I will confine myself to a few points on the new mental health deferral and will then turn to the topic of advance requests, as we call them in Quebec, or advance directives for cognitive neurodegenerative diseases. Excluding mental health can only lead to legal challenges and a cumbersome and unacceptable process for these patients. This political decision would run counter to the interests of the few patients who might otherwise be assessed, as is their right. Whereas expanding the eligibility to medical aid in dying to these patients would make it possible to comply with the Supreme Court of Canada's decision of February 6, 2015, as underscored by the Senate in 2021. Indeed, unanimously, judges have never excluded mental illness. This exclusion will force patients whose lives have already been shattered for decades, to go back to courts to force the government to respect their constitutional rights. For context, I recall the writings of Justice Beaudoin in her decision of September the 11th, 2019, rendered in the Superior Court of Quebec. Paragraph 252 of that decision, and I quote, free translation, vulnerability must not be understood or assessed in terms of a person's membership in a defined group, but rather on a case-by-case basis, at least in the context of analyzing Section 7 of the Charter, end of quote. This bill means that the suffering of people with mental disorders will be extended for a further 3 years, on top of the 3 years that have already elapsed since March 2021. Further delays continue to stigmatize people suffering from mental disorders, despite the fact that the report of the Pan-Canadian Expert Panel commissioned by the federal government that cognitive diseases. Minister Mark Collins said he has no plan to act on early applications in the near future. However, in Quebec, the right has had force of law since June 2023, and alignment with the criminal code is necessary so that patients who wish to avail themselves of this right can be assessed by providers who will not have to fear criminal prosecution. Our association therefore urges the federal government to take steps to make concrete progress on this issue. While Ottawa delays, patients suffer. Each year, there are 14 new cases per 1,000 people aged 65 and older, and 17 new cases of Alzheimer's per 1,000 people aged 90 and over. Neurocognitive disorders affect more than 15 people every hour of every day. By 2030, Canada could have nearly 1 million people living with neurocognitive disorders. Delaying the extension of eligibility to medical aid in dying will dash the hopes of many citizens. Those who are faced with terrible losses of personality will be obliged to shorten their days while they're fit not to find themselves trapped in indignity. The Special Joint Committee has already recommended that you go ahead with early requests, early applications in its February 2023 report. Approval for this measure is overwhelming across Canada. Quebec developed its legislation on advanced requests or directives for medical assistance in dying after an in-depth consultation reflecting the specific values and concerns of our province, as well, though, as those of more than 80% of Canadians. We are asking you to consider all avenues that will enable Quebec to activate its humanistic legislation this spring and thus meet the expectations of thousands of Quebecers. By authorizing advance requests, you have the opportunity to demonstrate your commitment to participatory democracy, the institutions of Quebec, and respect for individual rights at end of life, in addition to demonstrating humanity and compassion. It's important to emphasize that eligibility for MAID brings serenity and peace of mind and enables people who suffer to live fully in the present moment without the anguish of a long road of anticipated suffering and multiple losses of dignity due to a disease that will inevitably lead to their death. Thank you for your attention.
Et merci à vous.
And thank you to you, Dr. Espérance.
Dignity Canada, Helen Long, the CEO. Ms. Long, thank you so much for being with us. I know that you didn't have very much notice, but I also know that you're very well steeped in the topic. So welcome to the committee. You have the floor for the next 5 minutes. Okay. Ms. Long, you're on mute. Okay.
Sorry about that. Okay, thank you very much for having me, and good evening, members of the committee. I appreciate this opportunity to testify on a matter of profound concern to the people across the country who are afflicted with severe treatment-resistant mental disorders. I'm drawing upon a submission we made to the Special Joint Committee in November of 2023. This is an issue that concerns us deeply at Dying with Dignity Canada because it speaks to the rights of persons who have both historically and presently been deprived of Section 7 and 15 Charter rights to make autonomous and lawful decisions concerning their end-of-life choices simply because their illness is psychiatric in nature and not physical. The bill before you would extend the denial of access to MAID assessment for those whose sole underlying condition is a mental disorder for a further 3 years until March of 2027. Given that C7, which brought in the right to a MAID assessment for those whose death was not imminently foreseeable, passed in 2021 with a sunset clause excluding that access for those with a mental disorder for 2 years, and that was extended for a further year, this means that in total, persons in this category will have been denied the same set of MAID entitlements as those with a physical illness for 6 years. It is outrageous to suggest that the development of a regime for MAID MDS-UMC needs 6 years. It is especially egregious given all of the metrics that the government set for readiness in its last delay have been met. We have a nationally accredited curriculum and willing, competent assessors and providers. We have practice standards against which regulators of physicians and nurse practitioners can oversee that conduct. No new metrics are set in Bill C-62. What more is left to do? We need to look to those who are doing the work of providing MAID assessments and provisions, the regulatory bodies charged with the oversight of clinicians' conduct, the 127 physicians and nurse practitioners across this country who have confirmed in writing that the MAID system, MAID assessors and providers, and psychiatrists who wish to be involved in MAID MD-SUMC and who have testified that they are ready. The regulatory authorities, and most importantly, patients with severe treatment refractory conditions who are ready for MAID MDS-UMC. No new metrics have been established for this delay. Adequate safeguards are in place, including the requirement for a minimum 90-day assessment period, the need to consult with an individual with expertise, a psychiatrist in these cases, and so forth. We endorse the coming into force of MDS-UMC because we have a duty to safeguard the rights of all Canadians, in this case, a small group of people tragically afflicted with acute treatment-resistant mental disorders, who despite many interventions over long periods of time, have experienced unremitting suffering in their lives which cannot be relieved. At DWDC, we hear from those who, for reasons of fear, embarrassment, or stigma, are reluctant to speak publicly about their afflictions, but who know only too well what deep, unrelenting suffering means. And even more regrettably, we hear from those who will not speak publicly for fear of being ostracized by their own communities. Often their voices are drowned out by those purporting to speak for them. You're likely all familiar with the story of John Scully, who has spoken publicly for several years about his mental disorder. But I also hear from Jane and Kathy and others who are not able to speak publicly. Canada regrettably has a long history of paternalism and arbitrary denial of rights of those with mental disorders, and often we have unfairly conflated mental illness with a lack of capacity. In Starson v. Swayze, the Supreme Court of Canada, discussing the need to redress decades of unfair presumption of incapacity in relation to the mentally ill, wrote, "For this reason, it is particularly important that autonomy and self-determination be given priority when assessing individuals in this group." Every year, we hear from thousands of people across Canada who are seeking information or navigating the MAID coordination program across the country. Since Bill C-7 passed, the proportion of these individuals who identify as having a mental disorder as either a sole underlying medical condition or a comorbidity continued to rise. We anticipate that many of these individuals will likely never be found eligible for MAID MDS-UMC, but we cannot continue to deny them the right to apply. Doing so only serves to create further distress and angst. They have been left in an untenable position, unable to apply and suffering grievously. Thank you.
Thank you, Ms. Long. That concludes our opening statements, and we're now going to proceed with rounds of questions, beginning with the Conservatives for 6 minutes. Dr. Ellis.
Thank you very much, Chair. Thank you to the witnesses for being here on this difficult evening. certainly MAID for mental illness has been talked about for an incredibly long time, but to have the caliber of witnesses we have with us in this short time this evening is incredible. Dr. Gand, if I could begin with you, just to try to make it more realistic for Canadians out there, you talked about the difference between suicidality, which indeed is, if I'm not mistaken, is often one of the criteria for diagnosing depression, and perhaps the inability, as you mentioned, to distinguish it from the desire for MAID. Maybe just for everyday Canadians, if you could talk a little bit about that, sir, if you could.
Thank you for the question. I think it's a very important one because, in my opinion, Canadians have been given false reassurances that the sort of suicidality you're talking about, that's a result of mental illness symptoms, that can somehow be separated from other motivations leading to MAID requests for mental illness. The evidence in the few European countries that allow and provide MAID for mental illness shows that not to be true. In fact, there are overlapping characteristics between those populations. And the key issue here is that people with suicidality from mental illness, when they attempt suicide, they do not typically succeed, nor do they typically try again. And so that 2-to-1 ratio of women to men that I mentioned, of women to men, that stunning gender gap, which I have not heard a single expansion proponent address in any meaningful way. I would very much appreciate if any of the other witnesses tonight were willing to address that. But that stunning gender gap of 2-to-1 women for men getting psychiatric MAID in the European countries, we think that reflects gender-based marginalization. And for any psychiatrist, that should be a terrifying statistic because it parallels the 2-to-1 gender gap of women to men who attempt suicide when mentally ill. And most do not end their lives by suicide, and most do not try again. And what it points out is that people with suicidality from mental illness, we do try to bring interventions and suicide prevention that can help. We have no way of knowing whether that's what we should be doing or saying, no, instead you go through door B, where we're going to facilitate your suicide. The CAMAP guidelines, in my opinion, and I've openly said this, they dangerously provide a reassurance that they're doing something they do not do and they cannot do. I've looked at those, and this is actually quite literally, this is their stuff on suicide. It's 10 slides. They say it takes about 10 minutes to go through. That includes a 4-minute audio clip. And there is nothing in there that actually helps separate the suicidality that we want to help with suicide prevention from psychiatric MAID requests, except one is impulsivity. They focus on impulsivity. The reality is that the evidence shows, and this is from the CCA report, that in Western countries such as Canada, impulsive suicides constitute a small percentage of all suicidal deaths. And they often occur when a person has consumed alcohol. And it goes on. But the point is that many suicides here are not impulsive. And so that doesn't help differentiate. And the only other differentiating characteristic, when you go through their whole list of questions, is literally, is the person planning on doing it themselves, or have they come to you as a MAID assessor? Is that how we're deciding what's suicidal and what isn't?
Thank you very much, Dr. Gand. You talked about the CAMAP guidelines or curriculum, the Canadian Association of MAID Assessors and Providers, just for folks who aren't familiar with it. You mentioned very clearly that it doesn't help with determining suicidality versus seeking MAID. Maybe you could just talk a little bit about those guidelines. Again, I've gone through them myself, but we talk about assessing irremediability, which, of course, I believe is an impossibility. And I wonder if you've looked at that curriculum with respect to how it might teach physicians or nurses how to do that. And I know I don't have much time, but just to plant a thought in your head, as I see it, the CAMAP curriculum is for primary care physicians or nurse practitioners. The likelihood of having psychiatrists performing these assessments with the inability at the current time to access a psychiatrist is almost zero.
Well, there I would say there are some psychiatrists who are willing to perform these, but in my opinion, they're willing to perform these in the absence of evidence. The fact they're willing to do something that evidence shows they can't should not be reassuring. But I have looked at the evidence of this, and once again, there is no evidence that shows we can predict irremediability in mental illness, and it is vastly different from other medical conditions and neurodegenerative diseases.
And Dr. Gand, tell us a bit about perhaps the future. Not that I think you can predict it, but when we look at where we've come with respect to diagnosing and treating mental illness of all sorts, what do you see in the future that should give us all hope around this, that we should not have made for mental illness?
I think that there are many promising developments in psychiatry and mental health. I'm not trying to suggest that we're always able to help everyone. I think we all recognize that that can be challenging sometimes. But we have to remember what MAID is about. MAID is about us predicting who will never get better, and we can't do that. And if we can't do that with mental illness, we would be providing death under false pretenses.
Thank you, sir.
Thank you, Dr. Gain. Thank you, Dr. Ellis. Next, Dr. Hanley, please, for 6 minutes.
Thank you very much. And I want to echo Dr. Ellis in thanking the witnesses for gathering not just on Valentine's Day, but in an evening and on short notice, and being able to provide us this really useful testimony. I think obviously there have been years of deliberation on this, including the recent committee meeting. So I'm trying to put this into my questions into a framework of what now? What do we do after Bill 62 in terms of next steps? And how do we best prepare? So I'd like to just maybe start with Dr. Gagnon. Sorry, not Dr. Gagnon. I believe, Dr. Esperance. Pardon, Dr. Esperance. And I just want to understand more about what we can learn from the experience of Quebec, where you see that the direction in Quebec for particularly for MAID eligibility for mental illness. I understand from Bill 11 that this is a permanent exclusion. Is there anything that we can learn as a country from the deliberations of Quebec? Where do you see that Quebec's health system is in terms of readiness for mental illness as a sole medical underlying condition, and how do you reconcile with the direction of legislation in Quebec?
Merci beaucoup.
Yes, thank you very much for the question. Well, in truth, there is no actual lived experience yet in Quebec other than our experience with mental disorder, given that we are under the same Canadian criminal code as the rest of Canada. What's happened is that the committee in Quebec that has worked on expanding access to MAID in situations of medical disorders for patients who suffer solely from that as a medical condition has been set aside because there weren't enough elements to ensure social consensus on this matter. However, the report tabled by that committee was written up before that of the expert committee mandated by the federal government in May 2022. So there was a gap there in timing. So what would Quebec's position be now that the expert panel's report has been tabled? I can't say. I'm not a psychiatrist. Luckily so for any potential patients I might otherwise have. But I'm basing my opinion on expert opinion, in particular in the Pan-Canadian expert panel report, again mandated by the federal government. The concept is not to exclude them totally, that would be denying them rights, but to have very specific safeguards, very tight safeguards that would apply over time. And in the discussion, of course, what's at issue is pathologies that last for 20, 30, 40 years, patients who are highly deteriorated due to a mental condition.
Ms. Long, What since the report was issued by the special committee, the most recent report, the road ahead, what are you hearing from Canadians?
Yeah, thank you for the question. Certainly, I think we have tried to share the news that a possible delay was forthcoming in a staggered, bite-sized way so that people were better able to digest that and to understand that there might be a delay. There are people who will call very distressed. We've made more crisis calls, so calls for police intervention in the last 2 months than we have in the last 3 years, because people have been waiting. And, in many cases, we believe, based on our consultations with clinicians and assessors, we believe that many of these people will never be eligible for MAID, but they need to know that they can apply. They need to be able to move on and make the next step. So we heard from people who are very significantly upset and angered and impacted by the changes and the continued delay. And the thought, for people who, when the bill first passed and then it was 2 years and then it was another year, to hear, okay, now it's 3 more years, for these people who've been suffering for decades, who have tried every treatment, if you read the stories on our website, they've tried every treatment multiple times over years. This is just devastating for them, devastating. I can't impress that upon you enough.
Do you do you believe that there is a social consensus? And if there isn't, do you see a role for the Supreme Court? Do you anticipate a court challenge?
Yeah, well, I'm not a constitutional lawyer. I think the committee previous has certainly heard from those experts. I do think that there will be a challenge at some point. There has been, that has been raised multiple times in the past. And I think each time the people who felt they might stand up as plaintiffs thought, well, I can get through 1 more year, or I can get through these first 2 years. So I think now that we're at what will be 6 years and there's 3 years to go, I do believe that is a very likely possibility.
Thank you, Ms. Long. Suite, Monsieur Thériault, pour 6 minutes, s'il vous plaît.
Mr. Thériault, you have the floor for 6 minutes. Thank you, Chair. To begin with, I would like to share a comment regarding our 2 psychiatrists here present, and I will also ask them a simple question, given I haven't much time, and then I will move on to Dr. L'Espérance. From what I understand, from what these 2 psychiatrists have told us this evening, is that they share a similar opinion. And they have come as individuals to explain to us that they disagree with the Canadian Association of Psychiatrists, the Canadian Bar Association, the Association of Psychiatrists Quebec, the Federation of the CMA, Canadian Medical Association, the Canadian Association of Assessors and Providers of MAID. There's many comments to that effect, and Quebec's Medical College. And then Mr. Gained adds that these are ideologues, people who have ideologies, the sort of thing that we used to see in the old Soviet Union, science versus ideology. When you disagreed with the other side, you call them scientists, but in a funny way of using the word science. Now, we could debate this elsewhere, but Bill C-62, I haven't heard much said about it. There is a very important thing in C-62, being, are you for indefinitely extending the temporary exclusion, putting it off forever? Do you agree with the 3 years? Do you agree with forever, or do you agree with 3 years? It's simple. I'd like to know your answer to that. 3 years or forever? The exclusion. Dr. Gagnon, could you begin?
C'est-à-dire que...
Okay. Well, at present, the 3 years, I think it's wise because it is very difficult, as we tried to express, as I tried to lay out. It's very difficult at present to I'm not interested in the why. I would just like to know what your position is. Is it for 3 years or indefinitely? Well, based on current science, I would say indefinitely, but the 3 years is at least a political response. No, 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 no. I've heard, your justifications, but I just want, as a legislator, I would like your answers. Dr. Gain now. Are you for...
Chair,
Excusez-moi, Monsieur Thériault.
I'm sorry, Mr. Thériault.
Dr. Ellis.
I'd like to, if you would, sir, as we've had a understanding in this committee for a very long time, which I would suggest that you have historically applied very uniformly, that the witnesses have the same amount of time to answer the question as including the preliminary remarks that the asker of the question took. I would suggest to you, sir, that we keep careful close to the time and make it fair for the witnesses that they actually have the appropriate amount of time to answer the question, rather than continuing to allow Mr. Thériault to badger those witnesses. So I would, if you would please, sir, make those conditions clear to all present. Thank you.
Thank you, Dr. Ellis.
Monsieur le
Colleagues and
Président,
witnesses,
j'ai bien dit c'était quoi ma méthodologie.
Dr. Ellis is correct. We have adopted a procedure in this committee where the witness is allowed as much time to answer the question as the questioner takes to pose it. So by rights, I should have intervened to allow Dr. Gagnon a little more time, but I will simply ask Mr. Thériault to respect the rules that we have all played by to date. À vous, Monsieur Thériault.
Back to you, Mr. Thériault. My question then is simple and it's short. 3 years or forever?
Thank you, Mr. Thériault. Will I have time to answer the comments he made at the beginning? He characterized a number of things about my views on CPA and others. I can do it briefly.
No, not unless he allows you. The question that he posed to Dr. Gain did not include a 2-minute preamble. So
He defamed him in front of the entire committee, saying
So
it was an
it-
ideologue.
Dr. Gain, I expect that someone else may give you the time if to
I'll
address
answer
those
the question
things.
briefly. The 3 years, it depends what we do with it. If we go into it with a predetermined outcome, I think that is ideology. And it is not looking at whether the evidence shows us whether or not we can actually provide aid for mental illness safely.
Merci.
Thank you. Dr. L'Espérance. The committee has sat and has tabled a first report in February of 2023. We were to examine all examples and possibilities of extending or not the expanding access to MAID and so on. And the committee, with a majority, recommended going ahead with advanced directives. Perhaps it was wise on the government's part to wait to see what we would be able to do with mental disorders, mental illness, but they did not bring back into this legislation any recommendation regarding that. However, they put in word for word the special committee's recommendations about mental disorders in the bill. Is this surprising? What explanation would you have for this? And what light can you shed on what goes on in Quebec? The advance requests, as they're called in Quebec's advance directives, so that we have a better idea of how it works. I don't know why there's no further discussion about advance directives, although the committee's report did deal with it. Also surprising.
Mr. Chair, I do believe that the topic of this study that we are doing tonight is expansion of MAID for mental illness and not advance directive. And I don't believe that comment or that question is germane to the conversation that we're having tonight or supposed to be having tonight.
Monsieur le Président, est-ce que je peux répondre à ça?
Chair, may I respond? Yes, if you wish. However, first I was going to render a decision in your favor, but go ahead. Well, suggesting this is not within the topic, Chair, in the House of Commons in the chamber, there were motions and votes trying to bring this notion back to the floor. So I think that we, just to maintain things, we should bring this back.
Doherty, we have allowed a pretty wide latitude in terms of relevance. I also did hear reference to advanced medical directives in the course of some of the opening statements that were given. Those things, therefore, opened the door and made them fair game for questions. So Mr. Thériault's question is not out of order, and I'd like him to continue.
Monsieur le Président, j'aimerais ça faire un...
Mr. Chair, I myself would like up to present a point of order. Mr. Chair, I feel, Chair, that my Conservative colleagues are simply trying to interfere in the exchange which I wish to have with these witnesses, and I will certainly call on them to remain collegiate in their approach. If everyone intervenes every time we don't hear something that we would like, then we would be unable to sit at all, any of us. So I will call on you to ensure that our meeting goes ahead in a sensible fashion without too many interruptions. It's a matter of respecting the witnesses here before us.
Je vais faire mon meilleur effort.
I will do my best, Mr. Thériault. You have 1.5 minutes left. No, I certainly hope that my point of order didn't count into my time, the Conservatives' point of order either. That's correct. Each time a point of order was called, we did stop the clock. And so far, you have used 4.5 minutes putting questions to the witnesses. But you had said 2.5 minutes a little earlier. But anyway, you now have 1.5 minutes. Very well, then I'll allow the witness to speak. Let me specify that the issue of mental illness is one issue. The issue of advanced directives is quite a different matter. It is true that for mental illness there is no consensus, neither medical nor social. Among psychiatrists, we're told that it's a 50-50 split. However, for advanced directives for neurodegenerative illnesses, the best known being Alzheimer's, there is broad consensus across Canada. 82% of Canadians favor advanced medical directives. As I said, neurodegenerative disorders are a great weight on patients and on families. It's becoming more and more important, it's more and more prevalent, especially as the population ages. So an advanced directive allows someone with a well-established diagnosis to state, while they're still competent to do so, that they wish to obtain MAID when they will become incompetent in such and such a condition. That's basically what the law is in Quebec. In order to ensure that people remain dignified, are able to live in dignity, and also to give them a couple of extra months or even years with their family or with their loved ones, even if they've lost some of their competence. That's the principle of advanced requests in Quebec, respecting people's dignity for as far as they wish to go and live in dignity. Thank you, Mr. Thériault.
Gregor, please, for 6 minutes.
Thank you very much, Mr. Chair, and thank you to all of our witnesses for helping guide us through this part of the study of Bill C-62. I've been a member of the Special Joint Committee on Medical Assistance in Dying from the beginning, so I'm very familiar with the subject matter that's before us. Ms. Long, I'd like to start with you, if I could. Thank you for your opening statement and representing dying with dignity. Now, of course, ever since our Special Joint Committee tabled the report in the House of Commons and in the Senate with our single recommendation, we are also in receipt of a letter that was signed by the health ministers from 7 out of 10 provinces in all 3 territories. And if you look at that letter, you can quote from the middle of it where it says, quote, "The current March 17th, 2024 deadline does not provide sufficient time to fully and appropriately prepare all provinces and territories across Canada." And further down, they asked the Minister of Health and the Minister of Justice to, quote, "indefinitely pause the implementation of the expanded MAID eligibility criteria to enable further collaboration between provinces, territories, and the federal government. Now, Ms. Long, when I look at the signatories, they include ministers of health and ministers responsible for mental health and addictions. You can see that they are widely across the political spectrum. They include the NDP government in British Columbia to several conservative governments in other provinces. So I just want to know from you, how does Dying with Dignity respond to this letter, given that these are all cabinet ministers? They have executive level, functions within their respective governments, and they are responsible for the systems of health that are actually going to be overseeing this process. If they are publicly asserting that their systems are not ready, I guess how do you respond to that with your opening statement when you are saying that we are ready?
Yeah, thank you for the question. I think when you listen to the testimony that was heard in front of the committee, there was certainly indications from the regulatory authorities, for example, that they are ready. There was indication for individual clinicians, psychiatrists, nurse practitioners that they are ready. So while every province may not feel fully ready, certainly some of the conversations that we've had and the testimony that we heard, as did all the committee members, would indicate that there are people who are ready to move ahead. In terms of system readiness, from the provincial perspective, it's not clear what needs to be done. So I think that the question I would have for the individuals writing that letter is, what exactly are we looking for before the provinces determine that they're ready?
Okay, but with respect, I don't think these ministers, yes, they're all elected officials. I don't think they would have attached their names and signatures to a letter if they had not conferred with their deputy ministers, assistant deputy ministers, who are essentially the head of the civil service, who then would have gotten feedback from their respective ministries of health. So when you're talking about the regulatory environment, like if I was a cabinet minister, I wouldn't attach my name to this letter unless I'd had a nod of approval from my deputy minister. So how do you respond to that fact?
Yeah, thank you for the question. I think, for what we've heard is what we heard at testimony in terms of this issue. We're not clinicians, so we're not able to participate in all of those discussions, but it was certainly made very clear by the individual representing the regulatory authorities in the provincial health authorities that they are ready, and certainly that individual clinicians are ready. I think when we look to, C14 in the beginning of MAID, there was no time like this given for the provinces to be prepared in the way that they are today. We're probably readier now than we've ever been to move ahead with MAID.
Thank you for that. Dr. Gainde, I'd like to turn to you if I can. We've had previous interactions at the Special Joint Committee, and I recall in one of our previous interactions, we were talking about the Track 2 process that's present in the criminal code. And a lot of people have pointed to that as saying that, well, the necessary safeguards are already present. But I believe in your professional capacity, you've poked a few holes in that process. Would you mind informing the committee of some of the problems you've seen in the criminal code with the Track 2 process?
I'm happy to, and it actually links a bit back to Monsieur Theriault's question, which is trying to set a predetermined timeline by which we will have evidence, then we don't know if we will. So the holes are this. If we are saying to people that we are predicting their mental illness won't improve, we need to have evidence that we can do that honestly, and we don't have that. So whatever there is on Track 2 or Track 1 doesn't address that. And the separation of suicidality from psychiatric euthanasia requests also is something that the evidence does not show. So you can have people saying that they think they can do something. It doesn't mean they can. We had physicians saying that they think you should take ivermectin for COVID. It doesn't mean we should set a regulatory framework to do that. It's ridiculous. So what I'm speaking to is the evidence, not what any particular individual is saying. And in terms of Track 2, I will also say, by the way, that in terms of my own former professional association, the Canadian Psychiatric Association, of which I'm a past president, I find that the input they provided to this file has actually been shameful. In the things leading up, you're asking about Track 2. in the consultations leading up to Bill C-7, consultations on mental illness and death, they never once mentioned suicide prevention. They never once mentioned evidence related to suicide risks of mental illness or marginalized populations. That would be like a respirologist association never mentioning smoking as a risk factor for lung health. You go think what that means. I don't know what it means.
Thank you, Dr.
So, and the last point I'll make is that, in fact, in CAMAP guidance, they have a document that goes through how you can essentially convert people from track 2 to track 1, literally saying examples might include stated declarations to refuse antibiotic treatment of current or future serious infections. So I don't even know how many people on track 1 may actually be, by other people, considered track 2.
Okay. Thank you. Next, Mr. Cooper, please, for 5 minutes.
Thank you, Mr. Chair. Dr. Gained, proponents of this expansion, including the government-appointed chair of the expert panel, Dr. Gupta, have claimed that only a small number of individuals would be eligible for a MAID for mental illness. In fact, she said in her many years of practicing as a psychiatrist, maybe only 2 or 3 or a handful would be eligible. They cite the model practice standard to demonstrate, supposedly, that that would be the case. I would be interested in your thoughts.
I actually find those kinds of statements coming from some people who were in positions to actually suggest potential legislative safeguards quite remarkable. Because while Dr. Gupta says that, she also chaired the same expert panel that literally said they're not recommending a single legislative safeguard for MAID for mental illness. In terms of predicting irremediability of mental illness, her same expert panel, or the 10 remaining members, because 1/6 of them resigned, including the healthcare ethicist, but that same expert panel said that they would not or could not provide guidance on the lengths, numbers, or types of treatments that somebody should have had access to before getting MAID for mental illness. To me, this actually speaks a bit to some of the points Ms. Long and others have raised. You know, they paint a picture of, oh, these are people who have been suffering for decades and had multiple treatments. There's nothing in our legislation that requires that. It's an artificial picture. If you want a sense of actual evidence-based numbers of what this might be like, Scott Kim, who's a researcher at NIH, has done an evidence-based analysis, and he estimates several thousand people a year. And the things in the model practice standard and other things that are not legislated, that are not actual safeguards, they're basically suggestions. Suggestions are not safeguards. Reassurances without evidence are dangerous, in my opinion. This is a serious business. We're providing death to people who are not otherwise dying, and it needs serious safeguards. You know, if Kenneth Law was a doctor instead of a chef, how comfortable would you be with him being your mother's maid assessor? If there were just non-binding suggestions, empty reassurances, rather than legislative safeguards.
Thank you for that. You said that on the issue of irremediability and determining it accurately, that clinicians will get it wrong more than 50% of the time in cases where mental illness is the sole underlying condition. Would it therefore be a fair characterization to say that you would be better off flipping a coin, you're more likely to get an accurate result than otherwise?
In my opinion, it would actually be a more honest determination, because it would be openly showing that we're basing it on luck rather than the false reassurance of a white lab coat.
Now, with respect to this legislation, the government is providing a 3-year pause. But you cited two, as did Dr. Gagnon, fundamental clinical issues, including irremediability and distinguishing between a rational request versus one motivated by suicidal ideation. Are you aware of any evidence that you can point to that would indicate a likelihood or any evidence for that matter, that we would be on track to be ready for what would be a significant expansion of MAID in 3 short years?
No, I can't point to any, and none has come to light in the past 3 years either.
Dr. Gagnon, I will ask you if you have any thoughts on the assertion that has been made by the likes of Dr. Gupta and others that this would, if implemented, be limited to a very small number of Canadians who are suffering from mental illness for, in some cases, decades.
Yeah, well, quand on a effectivement.
Now, when we indeed examine the literature, quite to the contrary, and as I attempted to say in my opening statement, quite the contrary, studies show that these are often very common problems, very prevalent: depression, personality disorders, a loss, socioeconomic problems. So this is likely to ensure that a great number of people are eligible, especially in a context where the safeguards wouldn't be very strong or firm. Right now, they're even stronger. You see the safeguards in Belgium, the Netherlands, Luxembourg, and even there is an extension, an expansion of eligibility that seems to cover so many psychiatric states and psychosocial issues, so we can assume that many people would be affected. It's very worrisome.
Yeah. Mr. Cooper. Next, Ms. Sidhu, please, for 5 minutes.
Thank you, Mr. Chair. Thank you, all the witnesses, for being here. My question is to Dr. Long. Dr. Long, are you aware of the available resources supported by the federal government, which are assessing complex case, for example, curriculum, practice standard? Have they been helpful?
Yeah, thank you for the question. Just for clarity, I'm not a doctor, I'm not a clinician, so I am aware of those pieces and their development, but I cannot utilize them as I'm not a MAID assessor or provider.
Dr. Esperos, if you want to chime in that question.
Non, je vous remercie.
No, thank you. I'm not a psychiatrist, you see, so I can't really speak to the clinical aspects of psychiatry. I'm working from the data that the experts report, especially in the expert panel report. Also a document from 2019, if I remember correctly, regarding the state of mental illness cases and MAID.
Gap or challenges that limit the willingness of healthcare professionals to undertake those complex cases you're talking about, data. Have you seen that type of barrier or?
À moi, oui.
To myself, yes. What I am able to tell, and once again, based on the expert panel reports, there is data to the effect that physicians, psychiatrists, or the MAID providers can evaluate patients. But what's important to keep in mind and to understand is that for MAID, for all other types of patients currently eligible who have physical ailments, there are among them people who have mental illness issues, mental disorders, and who are correctly evaluated for their competency. Not only that, but in clinical practice, let's say in surgery more particularly, we too are called on to quite regularly deal with patients who do have mental disorders, whose capacity to make competent decisions must be evaluated. We must also evaluate whether they're suicidal. Let's say you have a 40-year-old patient who comes in with abdominal pain and tells their doctor, I want no surgery, I would prefer to die. It's quite clear that this doctor will be sent to psychiatry for a proper evaluation and will receive treatment, and then we will treat their physical ailment. Same for all physical ailments and diseases and disorders. So doctors generally are used to evaluating a patient's competency in day-to-day clinical practice when they're called on to do so. As for mental illness, though, I am fully convinced that there would be very few patients, given that the safeguards are already quite considerable based on the expert panel recommendations, being to extend or to ensure that the illness has been there for decades, not someone who turns up some morning saying, I just want MAID. You have to show that there have been decades of treatment attempts and so on. And please, there is no obligation to try all the treatments. That's a human right. Someone can turn down treatment. But when it comes to MAID, extended eligibility to persons with mental illness, such patients will have had to undergone some sort of therapy, but it's false to say that they must have tried all treatments.
To Ms. Long, should the government take 3 years to further prepare the system? What are your recommendations to the federal government on making sure system in provinces and territories across the country are ready?
Thank you for the question. I mean, we don't believe that the government needs 3 additional years to prepare. In the event that they go ahead with this delay, I think it's very important that there are clear parameters outlined that must be met, a clear understanding of what the expectations are in terms of provinces and territories, and a clear commitment not to further delay. I think in this case, the federal government sent the things that they thought needed to be established, a nationally accredited curriculum, a set of practice standards and advice to the profession, revised reporting under the Health Canada reporting system. Those metrics have all been met. So I think if there is a delay, there has to be a better way of establishing what the next set of metrics are and then ensuring that we get to them in a timely manner.
Thank you, Ms. Long. Mr. Thériault pour 2 minutes et demie.
Now to Mr. Thériault for 2.5 minutes. Dr. Gagnon, could you provide us with the studies that you have mentioned about the numerous cases, the numbers of cases referring to disorders that should not lead to eligibility to MAID and that could have been reversed, could have been treated? You also mentioned safeguards and safeguards needing to be stricter and that do exist elsewhere. Could you share that with us? And I'd like to deal with this in greater depth with you. You were referring to a report that you didn't provide a title for, but I imagine you have some idea of what safeguards would be required and what would they be? Well, the safeguards that they have in those countries is a psychiatric evaluation that we don't have, but look, the meeting that I see when it comes to undefined safeguards, I'm wondering how we'll resolve the fact that it's impossible to distinguish suicidal ideation from what might be considered to be an authentic request for euthanasia or MAID. That will be a difficult thing to manage. And also the irremediable nature of the medical condition. I've been a psychiatrist since 91, so I've spent nearly 33 years in this profession full-time, and I've seen so many cases, even after a decade, meeting a special person, a new event, a new treatment, completely changes, and they still have decades of life ahead of them, of interesting life, and all psychiatrists hope for this. Mr. Thériault, yes? What I would like would be to know what safeguards you are suggesting, because a psychiatric evaluation, recommendation 10 of the expert panel, that's, in there. So what further safeguards, not in the expert report, should be in the legislation? Well, this is why I think that legislators have drawn up this bill stating that, look, it's not simple, and I agree with that. I don't have an easy answer. It's not going to be simple, so a minimum of 3 years, I think this is wise, because it will take quite some time before we really hammer out what these safeguards should be. Right, but I don't want us to part on a misunderstanding. There's this legislation. The expert panel said that the criteria of version 2 of are insufficient, of track 2 are insufficient, but these safeguards could be laid on the legislation. They don't have to be in the criminal code. Moreover, the practice must be overseen by a professional medical college that will be able to sign off on the practices, and I think we can somehow manage that, can't we? That brings your time to an end. So perhaps you will have a chance a little later, another time around, when you have the floor next, Mr. Thériault.
5 minutes.
Thank you very much, Mr. Chair. Dr. Gain, every problem we've had with this particular issue of mental disorders as a sole underlying medical condition, you can trace it all the way back to that 11th hour Senate amendment to Bill C7. And, I was here during the 43rd Parliament. I was here in the 42nd Parliament for the first debate on MAID. But I remember when the charter statement was first issued for Bill C7, which I think reasonably explained the government's original position for excluding mental disorders qualifying for MAID. They recognized the inherent risks and complexity that it would present for individuals. They noted that the evidence suggests that screening for decision-making capacity is particularly difficult. They noted that mental illness is generally less predictable than physical illness. And yet, inexplicably, they accepted a very consequential Senate amendment. It seems that, we've just been constantly kicking the can down the road. The first delay was for 2 years. Bill C-39 delayed it by a further year. Here we now are with C-62 looking at another 3 years. And, I'm just wondering, first of all, what was your reaction at the time when the government did that 180-degree turn in their decision? And also, do you think that I think you sort of answered this, but I'd like you to expand on it a bit more. Can we actually ever be ready on this, or are we just setting ourselves up for failure in 2027?
So in your last question, and I'm not trying to be flippant, but I think the only honest answer to the last question is we don't know if we would be ready in 3 years or not. This is why it's problematic to say we will be ready in 3 years when we don't know. And the reason we don't know that goes back to the first points you were making, which reflects the deeply flawed process that has been behind this in the first place, because we never asked those questions. We never actually asked those questions. From day one, from Senator Kuchar's Sunset Clause agenda, it was a predetermined course that we will offer this without asking those questions that need to be answered first. To me, that's really putting the cart before the horse. And what I'll also point out is that these key issues of irremediability and suicidality, I find it quite striking that it's actually not only the people who are expressing caution who cite those. Even the ones who have been at the forefront of saying we should be doing this have acknowledged that. Dr. Gupta has chaired a number of these expert panels. She also co-authored an AMPQ report in 2019, 2020, I can't remember which year, but in there they literally acknowledge, the Provincial Association, that irremediability regarding that, it is possible that a person who has recourse to MAID, regardless of his condition, could have regained the desire to live at some point in the future. They acknowledge that. And then they say, but that should be an ethical question each and every time. Well, when you're getting a medical expert opinion, ethics are fine, but I think people go thinking they're getting a medical expert opinion, not the person's personal ethical judgment.
Thank you,
And
Dr.
on
Gain.
suicidality, they've acknowledged that as well at the expert panel.
Thank you. Mr. Doherty, please, for 5 minutes.
Mr. Gupta, do you know are you familiar with the saying, I don't want to live, Mr. Gant, sorry, I don't want to live, but I don't want to die. What does that mean?
It probably means different things depending on the context, but it reflects a deep ambivalence that the person is not happy, and happy is too simplistic a word, but the person is not feeling that they're able to live. But it's not that they actually want to die. Usually what it reflects is they want to live better. They want either their suffering to be dealt with, they want the social situation to be dealt with. I see it as an abandonment. If we tell people in those periods of despair that we're going to collude with the despair that your mental illness is bringing, the hopelessness that it brings, and we're going to also say, you're never going to get better. And in brackets, we're also not going to help with the social situations you're struggling with, but we'll provide you an easy and quick death. What does that say about us?
I appreciate you saying that, because I said that exactly in my intervention yesterday in my speech, how far we have fallen as a society that we can perpetuate one's addiction, but we can't get them into recovery. We can allow somebody that is in despair to choose suicide rather than offer care and help when they need it. Dr. Gagnon, you mentioned that we are failing Canadians, and perhaps I'm putting words in your mouth, but it's my opinion that we are failing Canadians when we do not even have a national suicide prevention strategy. Your comment to that?
Oui, effectivement, c'est.
Yes, indeed. It's one of the real problems. And it's part of what contributes to the fact, I believe, that when these debates took place in Quebec a few years ago, decided to, put a break on this or even to exclude the possibility, because there's so much to be done. As you're mentioning, suicide prevention, be it but that, and associations working with patients who are dealing with suicidal ideation are very concerned about opening onto this sort of practice before we have in place prevention services and measures to help them. And that was very wise on Quebec's part to say, for the moment, we're not going to discuss this further. Perhaps so this matter will come back. It'll be socially acceptable to discuss it again. But right now, we don't have the services. We don't have suicide prevention. These are insoluble problems right now. The irremediability, the suicidality versus authentic requests for MAID. So this is where we're at.
We know the stats, 12 Canadians per day die by suicide, a further 200 attempt suicide. That's 73,000 Canadians attempt suicide every year, and those are just the stats that we know. How is MAID different from suicide in the context of those suffering from mental illness? Dr. Gang and Dr. Gagnon, please.
Well, this is precisely part of the problem. We don't know how it is or if it is. This is precisely part of the problem. And even, as I was saying, even some who are pushing for expansion have acknowledged that. The expert panel quite literally, this is a shocking statement to me, but they quite literally said regarding chronic suicidality that society is making an ethical choice to enable certain people to receive MAID on a case-by-case basis, regardless of whether MAID and suicide are considered to be distinct or not. I don't remember our society making that choice ethically. The 10 on that panel did.
Dr. Gagnon?
Oui, effectivement. Et
yes, that's the case. And look, I work in a hospital, and we discuss matters with doctors from other disciplines who are, let's say, used to MAID. And when we talk to them about this new open approach, they say, look, that makes no sense. How could you ever be possible? You know what? So if your job is to treat the suicidal, and also when I speak to psychiatric colleagues in psychiatry who have long careers, who've seen very heavy cases, they say, I would never be able, in my cohort of patients, be able to tell the difference between suicidality and an authentic request for MAID. So we have had a discussion with the Quebec Association of Psychiatrists, in particular with a very, very bright psychiatrist who says, I would never do this. I might, ask a colleague to take over a case. It's not theoretically against it, but he says, look, I can't imagine how I would be able to do this, despite his very vast experience, very, very difficult cases, complex matters of mental illness. So unfortunately, it seems we're unable to tell the difference right now. Thank you, Dr. Gagnon.
Next, Dr. Pawlowski, please, for 5 minutes.
Dr. Gain, Mr. Theriault in his questioning suggested that you and Dr. Gagnon were somehow outliers, and the majority of psychiatric organizations, psychiatrists, agreed with allowing MAID for mental illness. Maybe you could comment on that. What do we know about what psychiatrists think about MAID for mental illness?
So we actually know a lot now, and it is completely different from how it was represented initially in some of the earlier consultations. And the reason I say that is that, the CPA's position aside, we know that by a 4-to-1 margin on the most recent national survey, it was conducted by the Ontario Psychiatric Association, but it was actually a national survey, by a 4-to-1 margin, psychiatrists felt that MAID for mental illness should not be expanded this March. It parallels every other survey we know of for psychiatrists in Ontario, in Manitoba, wherever it's been done after the Sunset Clause came in, where by a 2 up to 3-to-1 margin, psychiatrists do not support expanding MAID for mental illness, even though they're not conscientious objectors. Typically, 80 to 90% of them, similar to me, are not conscientious objectors overall. They recognize the exquisite vulnerability that these issues pose for our marginalized patients and the challenges that we're talking about here. That's why they oppose it.
Thank you. Ms. Long talked about people with unremitting suffering. You've talked about the difficulty of determining irremediability, whether people really aren't going to get better. I know, as also a practicing physician, I saw someone over Christmas. I was working in a walk-in clinic, someone that I knew, and as soon as he saw me, he said, "Hey, Dr. Pawlowski, how are you?" I'd seen him repeatedly for either suicide attempts or suicidality over the years in emergency room. He would have been the exact kind of person that Ms. Long would perhaps say had unremittent suffering. And I was very gratified to see he seemed quite happy. And I asked him about what had changed, and he told me a whole bunch of things. Have you had the same experience with people that had been written off as being they'll never get better, who actually did get better? And maybe afterwards I can ask the same thing of Dr. Gagnon.
Yes, I have. That's precisely part of the challenge here. And this is why it's not an issue, as Ms. Long presents it, of autonomy. It's not an issue of autonomy about the patient. It's about, or capacity of the patient. It's capacity of the assessor to honestly judge when the person won't get better. And they can't make that assessment is the problem. And just yesterday, I was on a panel at the U of T Faculty of Law with the former head of the Ontario Bar Association, Mr. Orlando Da Silva. And if you get a chance to see that streamed, I highly recommend watching his portion of it. He very poignantly describes his own experience of repeated severe depression when he was suicidal and also, by the way, functioning, doing cases, trial law, and completely competent. And he knows he would have been able to get it and he would have wanted it. And he is very concerned about what this would do to people who would be in situations like he was.
Dr. Gagnon, the same question.
Vous êtes en sourdine.
You're on mute, I'm afraid, sir.
Sorry, I could answer in English if you want. Yeah, I saw some of these patients, and my colleagues always talk about these patients that improve, and they don't understand often why. Often it's a relationship, it's a life event, it's a change in therapeutics. And I had an example. I had I follow cancer patients also as a psychiatrist when they're depressed, and I had a patient like that. She was had severe borderline personality depression and had been suicidal for decades, always at the emergency room, like the patient you saw maybe. And then suddenly she had metastatic cancer, and she stopped being suicidal. And she told me, she said, before I had cancer, I always wanted to die. When I couldn't, now I could die and I want to live. And she had like 5 years of very, very productive and fertile happiness. And you see that all the time with the colleagues. So it's very tough to predict, and it's... and also what I wanted to add also, we always forget that now there's new treatments. I'm the chairman of the Department of Psychiatry at Laval University, and my job is to recruit young physicians with new techniques, new procedures, and they train all over the world. They come back to our center in Quebec City. You know, they go in different kinds of psychotherapy, neuromodulation, like, transmagnetic stimulation. There's all new treatments that are very promising. Ketamine treatment, psilocybin, and you have all these new treatments too that could be a game changer. So we forget also sometimes to talk about these new treatments that could really give hope and change the course of the illness. Thank you.
Thank you, Dr. Gagnon. Next, Mr. Majumdar, please, for 5 minutes.
Dr. Gain, you mentioned earlier when people commit suicide, those unsuccessful often don't try again. They often seek and receive treatment. Do you think this policy would mean that people struggling with mental illness who have the possibility of recovery and overcoming this illness will end up dying and never having the chance to recover?
That's precisely what I and most of my colleagues fear. You've hit the nail on the head that is exactly what will happen. And the problem is we will not know which of those people would have recovered. They will all go in the bucket of MAID assessors saying this would have never gotten better, and we will just assume they never would have recovered, and more than half of them would have. And I've actually heard from patients who have said they are fearful for the future and potentially not wanting to seek help when they get depressed again. Why? Because they're concerned that somebody is going to say to them, well, do you want MAID instead? And, we talked about the model practice standard. Remarkably, in that, it actually says that any adult who could be eligible, unless you already know somehow that MAID would not be with their value system or their goals of care, you need to advise them that MAID could be an option. That actually means any adult with a disability, because MAID could be an option for any adult with a disability. I don't know of any other country that has basically said something so permissive. Most say that the physician cannot be the one to bring it up because that can be seen as suggesting it from the White Lab Code.
And you called it the Ministry of what in your opening comments?
What I personally believe we should have is a Ministry of Dignity.
Well, shouldn't prioritizing be hope?
Living with dignity, sorry.
Living with dignity. Shouldn't prioritizing hope, more accessible mental health resources like my colleague MP Todd Doherty had proposed with his 988 hotline over hurt, what this government is putting first be that main goal, exactly as you've named your proposed ministry? In your professional experience, what has the data shown you? Do your patients get better with proper treatment and recovery?
Yes, the vast majority do. And what we know is that, as Dr. Gagnon was speaking of, there are also many treatments that our patients can't access. Even for basic care, we know that less than 1 in 3 adults is able to get the basic mental health care they need. And for the things like neuromodulation and other things that can help, it's even far fewer.
We have about 90 seconds left. So, Dr. Gain, in the stories I've heard from Canadians suffering from mental illness, hope seems really far away in a world of darkness. And there's a lot of darkness in this world today. Yet when given proper support network, treatment, medication, etc., these people cherish the chance at a better life. Do you think the government should be offering a second chance at a better life than a path with no return?
I think we should be working on helping people live better and to address their real suffering. We can't forget that they're suffering. And it's not just from illness symptoms, it is also from other things. In fact, suicide prevention doesn't focus only on illness. It focuses on living with dignity.
I appreciate the evidence-based advice you've provided this committee. You've published over 21 papers on this. It's a far superior background than to be some sort of suicide lobbyist. Thank you for being here.
You have another minute if you want it. You good? Okay, thank you. Mr. Maloney, please, for 5 minutes.
Thanks, Chair. I appreciate the opportunity. Dr. Gained. I was on the special committee. You and I have met before. In fact, I was on the special committee, the most recent incarnation, and the one before that, and I was also on the Justice Committee that dealt with C7. So I have some knowledge of this, but I don't profess to be anywhere close to any of you in terms of my ability to comprehend some of the challenges that we're dealing with, which is where I'm going to go with my question. Look, we're here dealing with a piece of legislation on a fairly specific point. We're not here discussing the morality of medical assistance in dying. We're not here debating whether it is constitutional or is it not. We're not here dealing with advance requests. We're dealing with whether or not this bill should proceed in its current form and why. So I'm not a doctor. There isn't a consensus on this. I've been on the committees for, as I said, look, we have 3 doctors on this committee, and I'm reasonably comfortable in saying I don't think we have a consensus at this table, and that's excluding you, Dr. Gain. So here's my question. So we have 4 witnesses here, 2 of whom, if I'm correct, have said we should not delay, 2 said we should delay. But as long, I want to start with you. Here's my dilemma. So we're tasked as legislators with deciding whether to proceed, that the system is ready or not. I've had the opportunity to hear from numerous witnesses, review numerous briefs, review all kinds of articles and information on all of this, and there's no consensus. You're here saying there should be no delay because we need to stand up for protect and safeguard people's rights, and I'll get to that in a minute too. But put yourself in my shoes. I've heard from all of these people, read all of this information, and there's no consensus. It's not even close to being a consensus. I'm not a judge. I'm not on a jury. I don't get to decide who's right and who's wrong. What I have to do is decide whether the system's ready. So if you're in my shoes and you're faced with that situation, you've got a whole bunch of people saying the system's ready and they're highly trained professionals, am I not doing the responsible thing by saying we should delay it and discuss it further?
I think if we go back, and thank you for the question, I think if we go back and look at what the government outlined as what was required to demonstrate readiness, that has been done, and the testimony did say that. I think people need the ability to make their own choices once they've engaged in reflection, once they've had treatment. I mean, we talk about people not having to have treatment, people not needing to see a psychiatrist. The MAID assessors and providers that I know are people who are careful and thoughtful in their work. No one is looking to help people die by MAID instead of helping them to live. I think, there's been a lot of stories in the media that would lead people to believe that there have been cases of wrongdoing. There are no cases of wrongdoing. There's been no criminal charges laid in the past. These are careful assessments done on a case-by-case basis. And, not being a psychiatrist, I can't speak to many of the points that have been raised. I think, Dr. Gupta and others.
I think I've given you adequate time to respond pursuant to the rules of this committee.
Thank you.
But you're not answering my question. You're putting forward your opinion again. So put yourself in my shoes, and you've got a large group of medical professionals, not like you, not like me, who are saying the system's not ready. What would you do in my shoes? Am I not acting responsible? It's a fairly straightforward question, ma'am.
I think you're acting responsibly in considering everything you've heard, but I think we need to listen to those who are doing the work and those who testified. And I don't believe the testimony.
We are. That's precisely my point, because there's a large number of them who disagree with what you're saying and say the system is not ready. So I'm doing precisely that. And my last point, while I have a few seconds, is in terms of safeguarding people's rights, does that not include people who might make a decision at a stage when it could be premature and who are potentially somebody who's going to recover? I mean, there's rights on both sides of the equation. It's not a one-sided issue, and that's one of the challenges I have with this discussion, is people pick one side or the other, and it's not black and white. So when it comes to people protecting individuals' rights, you have to look at both sides of the discussion. Is that not fair?
Okay. Ms. Long, that's Mr. Maloney's last question. Take 30 or 40 seconds to answer it. I won't let him interrupt you again.
I think we need to listen to the clinicians who are doing the work, who believe they can assess in these very specific, unique circumstances. And these, every individual needs to be considered on their own case-by-case assessment and their own merits. I think we need to listen to the testimony. Yes, there were testimony on both sides, but I think if you look at the totality of the testimony, there were certainly at least as many, if not more, people who testified that they were prepared to move ahead.
Thank you, Ms. Long. Suite M. Thériault pour 2 minutes et demie.
And now, Mr. Thériault, 2.5 minutes. Yes, Dr. Gagnon. The CAMAP, the Assessors and Providers of MAID, have said that a group of experts also said that suicidal crisis, and of course they won't be admissible to MAID. So they're, of course they wouldn't be admissible or eligible in a crisis, in a suicidal crisis. You've mentioned suicide prevention. Someone who is in a suicidal state is reversible. I mean, that's obvious. It's no matter of their being eligible for MAID. Why are you confusing the two? A new request where an evaluator, an assessor would see that there were structural vulnerabilities. Well, of course they wouldn't accept that the person is eligible. You say there's no safeguards, but there are safeguards. These people have ensured they have safeguarders. They carry out evaluations. They discuss these with their peers, and they say among themselves that, of course, a patient would not be eligible in such situations. I'm sure you agree to that? Well, look, when it comes to suicide, yes, of course, one can be in a suicidal crisis, but I gave an example earlier of someone who was suicidal on a chronic basis and then gets better, who was really suicidal for 20 years nonstop and then gets better. So, yes, it can be acute, it can be chronic. There are many presentations. So that's why we say it's extremely difficult to tell the difference and to distinguish whether this is a suicidal patient or a patient making a competent, authentic request for MAID. And we're unable to do so. There may be some obvious cases, but there are so many others that aren't. And that's where it becomes difficult. Right. Those who are extremely difficult, though, must bend to the criteria, the safeguards that the expert committee has set up. And these safeguards exist. They're very real. They're on paper. We could discuss them, but we can't in 2 minutes. No one could say that there are no safeguards. I've asked you what extra safeguards should be added to the current list, and I would like an answer. I would have liked an answer about further safeguards, simply speaking, what could we actually do to improve the legislation? Well, it's complex, given that there are some theoretical and practical issues that are extremely complex when it comes to suicide and euthanasia and the irremediable nature of their conditions. And this must be studied further. This has been put off for a couple of years, and we still can't get to the basis of this. And that's why we say it will take a long time before we come to any sort of final answers about the right safeguards. But meanwhile, patients are suffering. So that brings your time to an end, sir. Mr. McGregor.
Mr. Chair. Dr. Gain, I want to step back from this and approach it from a Charter of Rights and Freedoms angle. And I know you and I are not constitutional experts, but what's invoked when we're looking at this provision is Section 7, the security of the person, the right to life, and so on. And basically, the lay person's interpretation is that everyone has the right to make decisions about what happens to their own body. And then, of course, Section 15, the equality rights, that everyone has equality under the law. And, of course, Section 1, in that some rights of the Charter can be justifiably infringed upon, by a free and democratic society. My struggle through every aspect of my work on the Special Joint Committee has always been trying to find a balance between an individual's rights to make decisions about their own body, but also the need for society to sometimes step in and protect our most vulnerable. And that's been a real struggle for me, I won't lie. But I'm just wondering, from your perspective and from other physicians' perspectives, and when it comes to this particular issue of mental disorders as a sole underlying medical condition, how do you approach and find that balance?
That, and as you point out, I'm not a lawyer, so this is now just my understanding of it, obviously not my expertise. It's stepping outside of that. But I do recall that even in the original Carter decision, the Section 7 argument, I thought part of that was the issue of foreshortened life, meaning that if somebody is in a state where they can foresee they will get to a point where they cannot act to end their own life, and they choose to end their life earlier than that period of intolerable suffering, that's foreshortening their life. Therefore, that was one of the rationales, is my understanding, that MAID needed to be an option. That entire argument doesn't apply to mental illness, because while mental illness causes tremendous suffering, and sometimes it can affect capacity, although most of the time people remain fully legally competent, it very rarely takes away the person's agency to act to end their life or do other things. And so right there, you see some differences between some of the arguments that were made on that case in Carter, and people sort of forget about that. And it is a significant issue because, I'd alluded earlier to the difference between doing something for someone or someone doing it themselves. And when we talk about the right to my own choice, the way I think about that simplistically is that's the right for me to do things for myself. When I expect something being provided to me, that incorporates other things also. And so if we're expecting the state to provide an easier facilitated death, I think it's incumbent on us to think about how that plays out on everyone, not just, one person, but everyone, including vulnerable populations. And we know our laws can affect different people differently. As that poet Anatole France said, the law in its majestic equality forbids the rich as well as the poor to beg in the streets, to steal bread and sleep under bridges.
Thank you, Dr. Gahan. The final round for the Conservatives will be Mr. Doherty, please, for 5 minutes.
Thank you, Mr. Chair. Thank you to our guests again for being here. Dr. Gagnon and Dr. Gahan, you said some things that are resonating with me. I shared last night for the first time in my intervention on C62 that while I have spent every minute of being elected for the last 8.5 years of fighting for mental health supports for our frontline personnel, whether it's those that are struggling with PTSD or OSI, fighting tooth and nail for our country to adopt a national 3-digit suicide hotline. What I had not shared previously was that there was a time in my life that I struggled, and the thoughts of death consumed my whole being. I attempted suicide twice. And I'm living proof today that life is worth fighting for. And when I speak about fighting for those that don't have a voice, and I speak about my concerns for what Miss Long is saying, I don't believe there's enough safeguards that we can put in place that we can ensure that somebody that, like myself, was in a dark spot, that finds a permanent solution for a temporary problem. And I just appreciate your comments and your testimony, all of yours. I can respect all of the testimonies. And I think my worry is that there will be many people, if we expand this to those that are struggling with mental illness, many people, as I said earlier, that say that they want to die, but they don't want to be dead. But it is such a final act And I also have a loved one that has recently chose MAID. And while we hear about the safeguards that are in place, cooling off period, what have you, I also know that if that loved one of ours wanted it right away, they could get that. And so my worry is that those that are struggling with mental illness and want to die because of whatever situation they're in, if only we can provide hope for the helpless and care instead of despair, I think we can really make a difference. And so I thank you guys for your testimony.
I'll just say thank you for sharing that. It cannot be easy, and it takes deep courage too. And I also think it conveys a profound message of hope. So thank you for sharing that.
You have a minute and a half.
Just one, thank you, Mr. Chair. To Dr. Gained, one of the things that Dr. Gupta and others have repeatedly said on the issue of suicidality is that this is something that psychiatrists and medical professionals deal with all the time, so that there's nothing to be concerned with in cases of persons requesting MAID suffering from a sole underlying mental health disorder. Could you comment on that?
With respect to Dr. Gupta and others, including actually Senator Kuchar, who will say to psychiatrists, room full of psychiatrists who don't share this view, it's telling them that, well, this is one of your core competencies. We are trained to assess and address suicidality. Professor Gagnon was not confused when he said we can't separate that suicidality from MAID requests for mental illness because we don't know how to do that. Those are different things. So anyone who's providing that kind of reassurance, frankly, I would say selling a bit of snake oil.
Thank you, Dr. Gaines. Final round of questions will come from Mr. Nakvi for the next 5 minutes.
Thank you very much, Chair. And this is obviously a very sensitive, emotional, and many times personal issue that we're discussing here today. I don't profess that I have the depth of knowledge on this particular issue, especially as it relates to MAID that applies to people with mental disorder, as many members of this committee, given the extensive amount of work that has been done. My engagement on issues on MAID goes back to 2016, 2017, when Carter decision was being implemented, and I served as the Attorney General for the province of Ontario and worked along with the Minister of Health at that time to apply the federal law into provincial space. And what I do know from that work is that there needed to be a fair amount of work had to be done in terms of the system, the healthcare system, to be ready to apply MAID in a manner that, from a legal perspective, protect people's rights, but from a healthcare perspective, ensure that there were appropriate training and curriculum and safeguards in place so there is no abuse of any kind. So that's where I'm coming from. And for me, this bill, Bill C-62, is about whether or not the system is ready to apply the law as being passed by the Parliament. And it is of the view of the government, based on what we've heard from experts, based on what we have heard from the requests we have received from the provinces and territories, the system is not ready, and we need more time to do so, and hence the extension for 3 years. So I will go to Dr. L'Esperance first and then to Dr. Long and ask this question, that in their view, is the system ready to administer MAID for people with mental disorder as early as March 17 of this year, or it is appropriate and prudent to have an extension of time before we are sure that the healthcare system across the province, not just in certain parts of the province, but across the country, pardon me, is sufficiently ready to administer MAID to people with mental disorder. Start with Dr. Lesperance first.
Merci beaucoup.
Thank you very much for the question. I will provide a simple answer. It's not the system that administers medical aid in dying. It is clinicians, and clinicians across the country. Those who are members of CAMAP have worked very hard for 2 years now to provide safeguards, in particular over the recent year by making good use of the expert panel's reports. Of course, it's not an easy issue. We all agree on that. But it's not by extending the temporary exclusion for another 3 years, because we've already had 3 years. In another 3 years, we won't necessarily have moved further ahead than we are today. So it's a matter of clinical decision-making with all the necessary safeguards as recommended in the expert panel report. Once again, it's not an easy matter, but extending the exclusion of eligibility by 3 years will not change anything other than sort of pushing it off forever, as I said at the outset.
Thank you, Dr. Long.
I don't really have much to add. I think Dr. Lesperance dealt with that quite well. Certainly in all the conversations we're having with MAID assessors and providers, with psychiatrists, with regulatory health authorities, with members of the provincial health teams, there is readiness. And I think if there is a province that for whatever reason does not feel they can proceed, they don't have to do so. I think those that are ready should be able to proceed as soon as they're ready, and that would be March 17th for some.
So, Dr. Long, I'll go to you first, and I want to pick up from what Mr. McGregor was talking about when he was citing the letter that has been cited by most provinces and all territories, explicitly asking for an extension and making the point that the healthcare system in their respective jurisdictions, and they are responsible in the end of the day, is not ready, and requesting the federal government or this parliament to give an extension. Does that not indicate to us, and again, put ourselves, as Mr. Maloney was saying, put yourself in our position in terms of options available to us, but not to extend at least for 3 years, so that provinces and territories are ready to provide that particular healthcare provision for people who may need it?
And again, I think those that administer MAID are ready. The individuals that I speak to who work within the healthcare system indicate for the most part that they are ready. I don't know what it is that the ministers would be looking for in order to continue to prepare. So I think it would be very helpful to understand what they feel is missing in the system.
Thank you, Ms. Long. That concludes 3 complete rounds of questions, and we're at 5 minutes before 9. We're expecting the ministers at 9, so we're going to suspend now, and as we switch over to the other panel. Please allow me, on behalf of the committee, to say to all of you, this has been an absolutely fascinating panel. We very much appreciate your expertise, and how quickly you responded to the invitation from the committee. We gave you as much time as we had in terms of lead time, which is a lot less than we usually have, but you responded. You've been very patient and professional throughout the evening with your answers, and we are absolutely grateful to you for that. So with that, we're going to suspend and await the arrival of the 2 ministers. Thank you very much to our witnesses. You're welcome to stay, but you're free to leave. We're suspended. them tonight. From the Department of Health, Jocelyn Voisin. Assistant Deputy Minister, Strategic Policy Branch, Katerina Pintar. Director, Healthcare Programs and Policy Directorate. And from the Department of Justice, Robert Brookfield. Director General and Senior General Counsel, Criminal Law Policy Section, and Jeanette Etel, Senior Counsel, Human Rights Law Section. Before I invite you to bring your opening remarks, this is, I know, your first time before this committee, Minister Varani. We've adopted in this committee, I would say, a convention that has worked fairly well for us. And so I just want to make you aware of it. It's quite simply this, that you will be afforded as much time to answer the question as the person who poses it takes to ask it. It is the prerogative of the questioner to allow you to go longer. But if they ask a 4-second question and you speak for 10, they'll probably interrupt you, and I won't stop them. So with that, we're going to begin with opening statements, beginning with Minister Holland. I know it's been a long night for both of you after a couple of hours in the Senate. We appreciate you being here, and you have the floor. Minister Holland, please go ahead.
Thank you very much, Mr. Chairman, and good to be back in front of the Health Committee. We did just have a very productive session the last couple of hours with the Senate, getting an opportunity to talk through, which is a very delicate and sensitive issue, one that requires a lot of calm, patient deliberation. And I appreciate members of this committee for their input and work. I certainly appreciate the work of the Joint Committee as we attempt to navigate this very difficult issue. I think I'll start by making a very clear and important distinction, and that is between mental health and mental illness. Mental health, not only in Canada but across the world, is in a state of crisis. Coming out of a pandemic, dealing with the rise of very devastating wars, global economic uncertainty, the existential crisis of climate change. These are difficult times to be a human being. But the challenges that we're faced in mental health are completely separate and apart from the issues that we're talking about in Bill C-62 with respect to mental illness. And that distinction is an important one because a conflation is both dangerous and I would represent irresponsible. When we talk about mental health, the historic investments we're making in mental health across this country, cooperating with governments of every stripe. You know, I had an opportunity just yesterday to be in the Northwest Territories and announce our bilateral agreement on both aging with dignity and working together. Just the day before that was in British Columbia, announcing our Aging with Dignity agreement there. And of course, I've already announced the Working Together agreement with BC, with Alberta, with Nova Scotia, with PEI, and many more to come, with specific and detailed plans of how we're going to take on the challenges we're facing in mental health. But when we're talking about mental illness, we have to recognize that there are some people who are trapped in an irremediable situation where their state of illness is not able to be remedied through medical intervention. And so we have to ask the question as a society, indeed as a parliament, at what point do we allow a person on their own recognizance, if they have an irremediable condition, to be able to make the choice to access MAID? If somebody has suffered for 10 decades, for 10 years, 20 years, 30 years, 40 years, where they've tried absolutely everything, where they've gone to medical practitioner after clinician, after expert, and have never been given the opportunity to escape that mental health. When it is an illness, not a momentary mental health crisis, what do we do as a society? And that's what we've been trying to navigate. The decision we have in front of us now is to ask for more time to prepare the system. I've had opportunities to talk with health ministers. We had a very constructive conversation in Charlottetown when I was together with all health ministers, Mr. Chairman, in your home province, discussing how we navigate that, how we get the system ready. And frankly, we need more time. We need more time for Indigenous engagement. We need more time to work with provinces and territories to make sure they have appropriate safeguards. Talking with CAMH, we want to make sure that if there's a possibility that clinical guidelines are required to create uniformity across the country, we have opportunity to explore that. We need more time to work with the disability community and with the community of folks with lived experience. So a 3-year pause is appropriate so that we can deal with mental illness, which is separate and apart, and I'm welcome to have the conversation on mental health. But hopefully tonight people will not be conflating those two because they are two separate conversations. But we do need time, and I'm appreciative of the opportunity to be before a committee tonight, to have that conversation, Mr. Chairman, to take your questions, the questions of the committee, and to have this conversation. Thank you very much.
Thank you, Minister Holland. Minister Varani, welcome to the Health Committee. You have the floor for the next 5 minutes.
Thank you very much, Mr. Chair, and I'm pleased to be here to speak to Bill C-62, which proposes to delay the expansion of the eligibility of MAID to persons whose sole underlying medical condition is a mental illness for 3 years until March 17th, 2027. As members will be aware, this bill would also require that a joint parliamentary study be undertaken on the topic by a mixed committee of senators and MPs approximately 1 year before the new date of expansion. The very first thing I wanted to start with is by expressing my sympathy for anyone experiencing intolerable suffering. I want to acknowledge that mental illness can cause the same level of suffering as physical illnesses, and that having a mental disorder does not mean that an individual does not have decision-making capacity. Everyone deserves dignity and respect. As this Health Committee is aware, the Supreme Court of Canada's decision in the Carter case led to the legalization of medical assistance in dying in Canada. In that decision, the Supreme Court declared the Criminal Code absolute prohibition at the time on physician-assisted death to be unconstitutional, noting that it should be available to competent adults who clearly consent to the termination of life and who have a grievous and irremediable medical condition. That led to Canada's first MAID law in 2016. Many members were here with me in 2016 when we enacted that law, which restricted eligibility for MAID to persons whose natural death was reasonably foreseeable. Quelques années plus tard, dans la décision Truchon.
A few years later, the requirement that natural death be reasonably foreseeable was found to be unconstitutional by a Quebec trial court in the Truchon decision. The federal government did not appeal this decision. Instead, made the policy decision to introduce former Bill C-7 to expand eligibility for MAID to persons whose natural death is not reasonably foreseeable. This bill, as introduced, permanently excluded persons whose sole underlying medical condition is a mental illness from being eligible for MAID. During its consideration of the bill, the Senate made an amendment to make this exclusion temporary. The House agreed, and the bill as enacted would have automatically repealed the mental illness exclusion 2 years later.
That the government's decision to go forward with those expansions at the time was a matter of social policy. I appreciate, though, that there are those who believe that the Charter required us to act in this regard on mental illness, and I want to address this point directly. MAID is a complex and deeply sensitive topic, and there are important Charter-protected interests that arise in this area. On the one hand, there is the autonomy and dignity of individuals in making end-of-life decisions. On the other hand, there is the protection of those who are vulnerable and who might be at risk in a permissive regime. In its decision in Carter, the Supreme Court recognized the complexity of legislating in this area and suggested that Parliament's choices on how to balance these competing interests would be given a high degree of deference. MAID is a particularly complex in the context of mental illness. As noted in the various MAID-related Charter statements, these inherent complexities are the basis for the mental illness exclusion. Some of the complexities, Mr. Chair, include that the course of a mental illness may take is more difficult to predict than that of a physical illness, and many people with a poor prognosis will improve, at least in terms of their suffering, which may alter or impact their wish to die. Moreover, distinguishing between suicidality and a valid request for MAID becomes particularly challenging when suicidality may be a symptom of the mental illness that led the person to request MAID in the first place. The MAID mental illness exclusion is not based on harmful assumptions nor stereotypes about mental illness. We recognize, as Minister Holland has just said, that the suffering mental illness can cause is on par with the suffering that physical illness can cause. This exclusion is not a denial of this fact. We also accept, as I said at the outset, and as I will repeat here again, that the decision-making capacity of those who are mentally ill is well established. As we have said, we do believe the exclusion should be lifted when the healthcare system is ready to manage the inherent risks and complexities of assessing requests for MAID that are based on mental illness alone. Our provincial and territorial partners agree that more time is needed. Medical experts agree that more time is needed. The lack of consensus on this issue proves that more time is needed. This bill reflects the caution required to ensure the safety of Canadians and get this right. As the interests at stake are significant and the consequences, Mr. Chair, are permanent, we must get this right. Thank you very much.
Thank you, Minister. We will now begin with rounds of questions, starting with the Conservatives for 6 minutes. Dr. Ellis.
Thank you very much, Chair, and thank you, both ministers, for being here. Minister Holland, in your mind, is having MAID solely for mental illness a foregone conclusion at some point? Is that the destination we're going to get to?
It's my belief for folks who have an irreversible, irremediable mental illness from which they've sought all treatment and have been able to get no relief in many cases for decades, that eventually, when the system is ready, that people in that irremediable circumstance should have access to MAID.
Thank you for that. How do you propose to get systems ready with the two outstanding issues of suicidality and irremediability?
Well, so suicidality is an issue that's completely separate and apart. If somebody who has having suicidal thoughts, goes in and sees a clinical professional and seeks assistance, that's somebody who is able to be helped. Somebody who has a mental illness is somebody who, despite going and getting help for potentially decades, is unable to lift themselves out of that circumstance and is in an irremediable state that is in a state of decline, and so there's an important distinction to be made.
Thanks for that, Minister. You talked about suicidality being an incidental thing, but realistically, it's part of the diagnosis of many mental illnesses. Is that not true?
Well, I don't, as somebody who suffered greatly and spoken publicly about my own mental health challenges, I do not believe that suicidality is at all incidental. What I'm trying to do is make a distinction between the folks that we're talking about in Bill C-62 and folks who are having a mental health crisis.
That was not the question I asked you. What I asked you specifically is suicidal ideation is an important part of a diagnosis of many mental illnesses. That's correct, is it not?
Yeah.
Simple question.
Yes. If you are mentally ill,
Thank you very much.
then that
so how
absolutely
do you expect,
can be present.
then, Minister, to get systems ready when suicidal ideation is a part of the illness that you're talking about? That doesn't make any sense.
Well, but what we're talking about is somebody not who has a mental health crisis and has suicidal ideation in a moment. We're talking about somebody who potentially for decades, and this is why we need to take time so that we can make sure that we are talking about the same cases. I'm sure if I would posit
but when
to
you read the diagnosis...
well, let me just posit so that we're talking about the same thing.
I'm asking the questions, not you. Thank you.
Go ahead,
when
Dr.
you look
Ellis.
at the Diagnostic and Statistical Manuals, 5th edition, which talks about mental illness, suicidal ideation is an essential part of the diagnosis of, for instance, depression.
Well, so what I would say is, you being somebody who with a history within the medical profession, if you have somebody who has tried absolutely everything and has been suffering a mental illness for decades, at what point, at 1 decade, 2 decades, 3 decades, how long before that person has autonomy over their own decision? And would you not recognize the difference of somebody who's suffering for many decades
Minister,
and trying to get service versus somebody who's in a mental health crisis?
I'm talking about suicidality, which you said was something that came on suddenly, or I forget what your exact words were, but clearly that's not the case. The second part of it is irremediability. And what we know clearly with irremediability with respect to mental illness is that it's impossible to prove. There's many cases, you perhaps being one of them, who have gotten better from mental illness. And here we are today talking about irremediability, And we know that those two things, suicidality and irremediability, in no way are related to systems.
Well, irremediable means that you aren't able to remedy it. So it means that it doesn't get better. You don't get out of it. It means that somebody is trapped in an illness that doesn't allow them. And I think it frankly gets back to the point where physical suffering and mental suffering, and when there's an illness, which is a very different thing than having a mental health crisis. A mental health crisis is something you can get out of. Mental illness,
Minister,
where
those
it's
are your words.
irremediable,
Crises
means
are
it
your
can't
words,
be
Minister. They're
remediated.
not mine. Is diabetes irremediable?
Well, I mean,
simple question.
Is diabetes? No. Diabetes is manageable as a disease.
Mental illness is not manageable. Is that what you're saying?
There are certain mental illnesses that you would acknowledge and you've talked to doctors. I've talked to doctors. There's certain mental illnesses that people have not been able to escape.
Diabetes,
just as there's cancer.
Point of order, Mr. Chair.
Minister.
Mr. Chair, point of order.
Point of order from Ms. Sidhu.
Mr. Chair, I just want to say the last panel, we said rules should be followed and without interruption, please.
Look, it's fine, Mr. Chair. I would say that, can I just make this point very briefly? Cancer is irremediable.
I'm the one
it ends
the
in death, and it is irremediable. I mean, trying to make an equivalency between multiple different illnesses is I don't understand the point.
Last time, Sean.
Okay, Mr. Holland, you have, go ahead, Dr. Ellis. You've got another minute and 20 seconds.
Thank you, Chair. If I might remind you, Minister, I'm the one asking the questions, and if I have a question for you, as per the part of this committee, you need to answer it. The second part that we need to get to clearly is that this particular program that you have has a lack of safeguards. Substance use disorders and mental illness, post-traumatic stress disorder, which your government has offered to veterans, is a mental illness, as is autism. How are you going to square your circle with respect to irremediability with those illnesses?
Well, I think, first of all, I guess we just have different purposes in discourse. I ask questions for seeking clarity and to get on the same page. We're trying to deal with a very difficult issue. When you're asking me the question about irremediability, I'm trying to say that if somebody has an irremediable condition, and we're talking here about not some other disease, we're talking about mental illness, somebody who's trapped in it. And I would ask you the question. I mean, and you say you don't want me to ask questions. My purpose of my question isn't a political point. It's one of clarity. If somebody is in a situation for 20 years, 30 years, 40 years, at what point, when they themselves are the ones asking for relief and are saying that they are in an irremediable condition?
Irremediability, though, you continue to say you need to get systems ready. Irremediability is something that you can't prove. You can't make a system to prove irremediability. It's an impossibility. That's a clinical judgment by a clinician in front of that patient. It doesn't matter what you change the system to, you're never going to get to the point of irremediability. We've heard from multiple experts that they are the ones that making that decision around irremediability, not a system.
Well, what I'm saying is that, and that's why I posed the question, because I think it's important for clarity. If you have somebody who is trapped in mental health that is saying that they want to end their life, and they say that for 5 years, 10 years, 15 years, 20 years, and they've attempted all therapy, they've attempted everything in their disposal, at what point do you feel that they have autonomy over that decision? If the answer is never, well, then that's an ideological position. And I can't really there's not a lot further to go. But if the point is that somebody at a certain point of suffering has an opportunity to have autonomy over their own life, then, that's an important debate and one that is not rooted in ideology.
Thank you, Minister. We're going to move to Dr. Hanley, please, for 6 minutes.
Thank you very much. Thanks to both of you ministers for appearing and for your officials as well. And I appreciate your opening comments from both of you as well. I want to just briefly go to continue on the train of irremediability and suicidality. So in your understanding, Minister, is determining suicidal ideation and distinguishing suicidality not already a part of MAID assessment even as currently applied to someone with a physical condition and mental illness?
100%. And one of the things in our conversations with provinces and territories is we want to make sure the moment somebody expresses suicidal ideation that they have access to care and are channeled to a pathway of treatment. So the circumstance, even for somebody who was attempting, who said where mental illness is the sole underlying cause, and they wanted to proceed with access to MAID, even if this regime was permitted, they would need to demonstrate that they had tried everything, and there would have to be 2 clinicians that would have to validate that they had tried everything and that they, in fact, had an irremediable condition.
Step of interrupting you because I've got a
No, go
bunch
ahead,
of other
please. I was
questions,
too long.
In your understanding, also, because you've had many conversations with practitioners, are there physical illnesses where irremediability requires judgment on the part of the physician?
Yes, in many instances, there are physical conditions where you are told by a clinician that your condition is terminal and irremediable.
So it's not necessarily a black and white decision or something that is in a textbook. It's a judgment that is required.
Correct.
As it may well be required for mental illness. So given that this is such a difficult issue, as we've all acknowledged, are you punting a difficult issue down the road?
No, I think if we were punting it, then we would have voted for MP Fast bill, which set no date, or would have set this off for an indeterminate length of time. What we've said, and I could run through, I want to be respectful of the time that you asked the question. I can run through specifically some of the things that I think need to happen, but we need time in order for our work with the provinces and territories to get to the position where there is system readiness, and that isn't present today.
Yeah, and thank you. The one-year extension that was applied a year ago, there were 4 criteria applied, and a national reporting system, made practice standards to regulators in all provinces and territories, finalizing an accredited national MAID training program, and considering the final report by the Joint Committee of the House and Senate. So which of these criteria, in your view, have not yet been met?
Well, I think there was excellent progress made. I mean, there was the development of the MAID practice standards. There was the development and delivery of a national accredited curriculum. There were 1,100 clinicians who were registered, and I could go on. But I think one of the concerns is that there are only 2% of psychiatrists who've been trained at this moment in time, that of the 1,100 clinicians that have received training, only 40 of them have completed that training. And that, in talking with CAMH, there's the discussion about wanting to have clinical guidelines, and those would take time to develop. Lastly, if I could, just very briefly, the engagement with Indigenous leadership. As I've gone and I've had these trilateral meetings, they're asking for more time, and specifically 2025. And this is also true of the community, of folks with lived experience in the disability community.
Thanks. The letter from 7 provinces and 3 territories, we all know about that letter. How influential was that letter in respect of the committee recommendations? How did each of those weigh into your decisions?
Well, I'll be frank. When I became health minister and I had initial conversations, because of the points that you've just raised, there was enormous progress made in a year, and I really felt that the system might be ready. In Charlottetown, what I heard every health minister say is that they weren't ready, that they needed more time. That caused me to have a pause at that moment in time, and led me to a lot of other conversations where I'm reflecting on some of the things that happened here. I would say the Joint Committee in its testimony and work was also very important in coming to that determination. So it was certainly a part of the equation, the position of the provinces and territories.
Okay. And let's say that letter came from maybe 1 province or 2 provinces and 1 territory. Like, how would that have changed? In other words, if some provinces are stating that they in fact are ready, how can we justify holding back when they say we're ready to go and we have all the systems in place?
Well, I think the inverse is, maybe I'll paint the picture in an inverted fashion, which is that there was no province, no territory. All 13 said that they are not ready. And I had very thoughtful conversations with many different health ministers who completely agreed in the equivalency between mental and physical suffering. However, they were requesting more time to get their systems ready, and then that was an earnest expression, I believe, on their part.
Can I just point out to Dr. Hanley that in Quebec they actually legislated the fact that for mental illness alone this should not be provided, so they took a more active step than the letter.
Thank you.
Thank you, Dr. Hanley. Suite, Monsieur Thériault, pour 6 minutes, s'il vous plaît.
And now, Mr. Thériault, for 6 minutes, sir. Yes, thank you. So the way the bill is structured, it really uses the joint committee's recommendations other than for the 3-year. But apart from the Conservative Party, everyone felt that we weren't ready, but felt that in a year it would be by then wiser to go ahead, and that was a good timeline. But it seems to me that there has been an excessive slowdown. How is it that the committee tabled its report and there was a decision to be made a few weeks before a deadline, then suddenly the province has come out with a letter and we haven't heard anything about it for the last year? How is it that you are allowing the committee to come up with recommendations which become a bill? But, you know, it's really the elephant in the room. You're mentioning the constitutional rights of people who are suffering, but what are you doing for Sandra de Montigny? What are you doing for the principal recommendation, a majority recommendation of the committee a year back, which said that we need to go ahead with advanced directives? How is it that, though you had 1 year to prepare that track, so that the why is it being dropped? Why are people like Sandra de Montigny being brushed aside when there is a consensus across the land about her issue? It's a good question, and I appreciate your putting it to me. Of course, there are people who suffer greatly, and this is a horrible situation. I find it very worrisome. This said, it's clear that we need to make sure that the system overall is ready to launch this deep change to the MAID system, because the consequences, if it weren't ready, would be very serious. Over the last year, we have moved considerably on this. It's quite remarkable, as I explained to Mr. Hanley, but it still doesn't suffice. On issues such as the, yes, thank you very much, advanced directives, this is such a complex matter. For example, in a situation where someone is in a bad state, there's a member of the family who says, yes, MAID would be a good idea. The other member of the family says, no, that's not a good idea, and we're not even going to discuss it. The doctor says that the person themselves is incompetent, can't decide on their own. So there's a lot of situations like this. But let me stop you. This is disinformation. I mean, please, please, go and read the Quebec legislation. I mean, you lack rigor here. Of course, I'll hold back on this, but your response makes no sense at all to me. It's not a matter of members of the family, that one versus the other. In Quebec legislation, there's a third party who evaluates the situation. This is a third party who has been named ahead of time, and they are there to ensure that the person's will be respected based on criteria that person set out. And then the care team will say, look, I think the person is at this point. Will you please evaluate them? So a year ago, you came up with this recommendation. You were asked to deal with it, and now you're saying something as foolish as you are tonight. I mean, for heaven's sakes, I can understand why there's no bill before us if that's your understanding of advanced directives in Quebec. And Quebec is unanimous on this matter. And 85% of people across Canada expect this as well, because people are suffering. What are you waiting for? At least this evening, could you agree that we'll go ahead with this bill before the end of this legislature, this government, and inform yourself? Yes, I can understand why people want access to a system with advanced directives. It's very logical. But my point is as follows, and it's very different than from what's at issue here with this bill. It is possible today to say, in the future, if such and such a situation occurs, I would like such and such. But at that point in time, if the person were incompetent, unable to explain and state their situation and their need, imagine having someone else having to make the choice for them, the final choice. I mean, that's a major change. Because another person would be making a choice on this issue. Now, of course, I'm very open to pursuing this conversation, and I would certainly like us to discuss this in depth with all provinces and territories. I can assure you we shall and are. But it's a complex matter. But look, come on. Neurodegenerative illnesses, these are physically degenerative, where it's clear they're irremediable, they are really heading to end of life. This is objectively visible and can be determined objectively. So that being the case, we can't think it would be any more complicated than mental disorders, or we're with mental orders where people are a little bit worried about whether it's irremediable or not. Of course, not everyone agrees.
The earlier panel, Mr. Doherty made an objection, which I agreed with at the time. We're not here talking about advance requests. We're here talking about C-62. It's a piece of legislation with a very specific outcome. And as much as I appreciate Mr. Theriault's passion, it's not on topic.
Thanks for the intervention, but we've allowed it all evening. I'm not inclined to change it now. It appears that the ministers are ready to speak to it. Please, Monsieur Theriault, please, s'il vous plaît, posez.
Mr. Theriault, please put your question. And then we'll allow the minister 30 seconds to respond to it, because you're reaching the end of your time. All right. So will we have a bill? And will you please go and gather information so that we can ensure we could have that aspect covering people who are suffering? Will you examine the Quebec legislation and inspire yourself from it so that we can solve this once and for all? 85% of people back it across the country. Based on Ipsos, this is a real poll. So, to begin with, 30 seconds. Yes, we're fully aware of the bill that has been carried and passed in Quebec. But what I can say, Mr. Theriault, is that from the outset in 2016, we have moved forward in a precautionary fashion prudently with the intention of involving the entire country. And this is how we responded to the Truchon decision, and this is also how we have dealt with advanced directives. We will carry out a study involving Quebec, of course, and Quebec leadership prudently. Thank you. Your time is up. And we gave you extra time as well.
Please, for 6 minutes.
Thank you very much, Mr. Chair. Thank you, ministers. Minister Holland, I'd like to start with you just on the subject of the letter that was signed by 7 out of 10 provinces in all 3 territories. Now, in our first panel, we had some witnesses talking about, readiness in the system. But I'm assuming that these ministers would not have signed this letter unless they had confirmed with their deputy ministers, assistant deputy ministers, that in fact their system was ready. Now, you've had in-depth conversations with these members. You've probably had conversations with their deputy ministers. What conditions would have to be in place for you to attach your name to such a letter? Like, you would probably want to consult with your deputy minister to get that kind of assuredness from the healthcare system that you're overseeing. Like, I mean,
the letter saying that would be indefinite as opposed to 3 years?
Well, no, just like what conditions would have to be in place for you to sign such a letter? Like, would you want to check with your deputy minister first?
I always would check with my deputy minister.
Okay, that's a good point to put into place. Also, these ministers were very careful to ask for an indefinite pause. What caused you to choose the 3-year delay instead of listening to the ministers who have that oversight of the healthcare systems?
So there were detailed conversations with the health ministers, and part of it was how long was it going to take their systems to get ready. And one of the concerns was some of the ministers, really it was a question of readiness, and they acknowledged the equivalency between mental suffering and physical suffering. But a few of them, were simply ideologically opposed to the idea of ever proceeding in such a way. And I think that if we were to put it off indefinitely, then we'd see no progress in the system in terms of adoption of the curriculum or even belief that we were moving towards that. And that would leave people who are in unimaginable suffering, right? And we're talking about a very small number of people, but these are people who have tried everything and are stuck in unimaginable mental hell. And after, in many cases, decades of asking, are saying, I want access to MAID. And so that is a consideration here.
Thank you. I'm going to take issue with two of your earlier comments. I do think actually this issue has been punted down the road. It was punted down the road by 2 years with the Senate amendment. It was further punted down the road by 1 year C-39. Now we're looking at a 3-year punt. I also take issue, I've been on the Special Joint Committee since its inception. I agree with the recommendation that we put forward, but we did not have anywhere near enough of a time frame to study this issue in depth. We had 3 meetings, 3 hours each. So how can you say that this is not punting down the road, and how can you say that the Special Joint Committee had adequate time when in fact we did not?
Well, this, of course, was the second time the Joint Committee had been sitting, and the Joint Committee, in its previous iteration, had spent an extraordinary amount of time on the subject. So it was round 2, if you will, for the Special Joint Committee, and we're very appreciative of their work. But they did extensive work in the first round, and that wasn't very long ago. So, and the second point was that there seemed to be a uniformity of opinion within that Joint Committee that more time was needed. So, I don't know how much time you need to study. Once you reach a conclusion that you need additional time, keep studying to say you need additional time doesn't make a huge amount of sense to me. But in terms of punting down the road, I mean, you can use whatever nomenclature you want. The point here is that we have to ensure the system is ready. And if given the opportunity, I could talk about all the things that were done over that 1-year period and why we thought they would be sufficient. But the underlying reality is that it was insufficient and we needed more time. And I wish I had clairvoyance and could have known that, but lacked it.
Thank you. I'd like to turn to Minister Varani, if I could. Minister Varani, you said, you were, to paraphrase the Supreme Court, you were mentioning that they were going to give a high degree of deference to Parliament when legislating in this area because of how sensitive it is. Now, when C7 was first introduced, I thought there was a very reasonable charter statement issued which explained the government's initial reasons for excluding this. Then at the 11th hour, a very consequential Senate amendment was accepted. And that really, I think, is the root of all the problems that we're finding ourselves in today. Do you, as a minister now, have regret about that decision? Because I truly believe that that decision was putting the cart before the horse. And I'm speaking as a member of the Special Joint Committee. Minister, we have been playing a game of catch-up ever since. The law was changed in advance of the important consultation, in advance of those committee hearings. And as a result, we have had to constantly shift the timeline. So, again, why didn't the government exercise that high degree of deference, as you put it, that the Supreme Court gave you the room to exercise in the first place?
Well, I think there's sort of 2 issues there, Mr. McGregor. So the issue is what deference is accorded by the Supreme Court and your criticism of our response circa 2019, 2021 vis-a-vis mental illness. Do I regret that decision? Not at all, because I think what the Senate prompted was an active discussion about mental illness and the evolution of this law and its potential expansion and the development of the MAID curriculum, the model standard, things like oversight mechanisms that are under development is all a byproduct of that function. And I think that's proper vis-a-vis showing equivalence between mental suffering and physical suffering and not perpetuating negative stereotypes that the mental suffering does not deserve the same level of sort of treatment or being addressed, and also pejorative assumptions about people's decision-making capacity who are mentally ill. What I would say to you is that on the deference piece, Mr. McGregor, is that the court has said that there's a certain amount of deference owed as part of the parliamentary dialogue, the dialogue between the courts and Parliament. There's extra deference showed in a matter of complex social policy. And then they highlighted in the Carter decision that when it comes to MAID that deference is directly applicable. So what they're saying there is that they're going to allow a margin of maneuver for parliaments to try and get this right when you're balancing delicate interests. And I'll say to you what I said at the outset, is that when you've got issues of the unpredictability of the course of one's mental illness, when you've got the possibility of suicidal ideation being a symptom of someone's condition, you've got to make sure that while I firmly believe you can distinguish between suicidal ideation and a well-considered, well-thought-out request for MAID, that difference can be made, that distinction can be made, but we have to ensure that all of the healthcare practitioners, MAID providers, and assessors have the ability to do so. And when only 40 people have had that education, I think that's not enough.
Thank you, Minister. Mr. Cooper, please, for 5 minutes.
Thank you, Mr. Chair. Minister Holland, you have repeatedly claimed this evening that the only persons who would be captured by this expansion of MAID for mental illness are persons who have been suffering with an irremediable, irreversible mental health condition for a prolonged period, decades, and have sought all treatment options. That is false, and you know it to be false. Minister, on what basis can you peddle such a false claim?
So I would hope that anybody who's in a mental health crisis would come forward and would seek mental health services. And of course, under the regime that we're contemplating here today, that would mean that somebody would get help. They would not have access to the regime. And what I'm saying, sir, is that the people that I'm speaking to, these are very real cases with individuals who are trapped in mental
Minister, it's
health.
my time, and my
Go ahead,
question.
Mr. Cooper.
Again,
Go ahead, Mr.
There
Use
are
it as you
no
will.
legislative safeguards, none whatsoever in the case of MAID for mental illness. All that would be required is for someone to have the sign-off of 2 clinicians, not even a psychiatrist, not even a medical doctor necessarily, and they would then have the green light and would be eligible within 90 days. So what are you talking about when you talk about safeguards? Because there aren't any.
Well, it's just not true. And Minister Varani can speak to it as well, that the intention, I mean, first of all, let's reverse this. I mean, the accusation in the way that you're coming at me is if somehow I don't care about people and their mental health.
You made a very specific claim repeatedly.
You're being extremely aggressive with me and not allowing me an opportunity to express. So I understand you have a political point to make. It's a question of whether or not you want to hear my answer.
It's not a political point. It's about truth.
Go ahead.
Mr. Cooper, you're holding him a little too tight on the timeline. Take another 10, 12 seconds on this question. We'll move to the next. Go ahead. Okay, go ahead.
The safeguards are you must be informed of available and appropriate means to relieve your suffering, including counseling services, mental health, disability support services, community services, palliative care. Person and practitioners must have discussed.
It's my time. I'm reclaiming my time. I'm reclaiming my time. If you're referring to, and I'll go back to Minister Holland.
Go ahead, Mr. Cooper.
I'll go back to Minister Holland. If what is being referenced are the so-called model practice standard, that has no teeth. That is very different from a criminal code safeguard. And with respect to that so-called model practice standard, there's nothing there that provides guidance on the lengths, numbers, and types of treatments, nothing that all treatment options be exhausted by the patient. So in the face of that, how can you possibly claim that this will impact only a small number of people who've suffered over a prolonged period of time? That's simply false, and you know it, Minister.
Well, you can say that. It doesn't make it true. And secondly, you won't allow us to enumerate the ways in which there are safeguards. So you say there aren't safeguards, and then you aggressively talk over me as we try to talk about what those safeguards are. I would simply posit to you that the eligibility criteria is extraordinarily strict, that the model practice standards being incorporated by the provincial regulators will be similarly strict, that the criminal code, if somebody violates those, is a criminal violation. It is not a light matter, and that my interest has been expressed.
My time, and I would cite.
And you're certainly making it clear what your time is about, sir.
Here's a fact. There was a survey released from the Ontario Psychiatric Association that provides that 78% of Ontario psychiatrists, this was released 2 weeks ago, are of the view that the current so-called safeguards are insufficient and will result in the inappropriate applications of MAID for persons who are struggling with mental illness. In other words, wrongful deaths. Why would Canadians believe you and trust you over 78% of Ontario psychiatrists?
First of all, my interest, like yours, is to protect life and to make sure that people who are suffering get every opportunity to get the help that they need. Two, that the situation that exists right now is asking for additional time, because we do believe safeguards are present, and I've just talked about some of those, but we think we have to go that much further to make sure those safeguards are there, so that people that are trapped, and by the way, we're talking about people in their own volition in an irremediable mental illness circumstance.
Minister, there are no legislative safeguards.
Well, you can say that.
Well,
I mean,
you
it's
haven't
your
cited
theater.
one. You haven't
continue
cited
to play.
any.
Yes.
You haven't cited any, and you haven't responded to the fact that 78% of Ontario psychiatrists believe that whatever so-called safeguards that will be in place are completely insufficient. We're talking about wrongful deaths when there's an inappropriate application of MAID. That's what we're talking about.
So we're talking here in this legislation
is what you've demonstrated is that
no, we're taking
ideological.
First of all, I'm just going to say I reject.
You're playing with people's lives.
I reject that totally. I reject
it's absolutely disgraceful.
No, what is disgraceful is mischaracterizing my position or mischaracterizing the position of any member of Parliament, sir. Saying that any member of Parliament doesn't care about any human life is a disgraceful thing that I will not tolerate.
Well,
and for you to step into this committee and make an accusation of any member of Parliament that they do not care about the life of another human being is absolutely beyond reproach, sir. I have spent my entire life, as you have, fighting for the good in this world. And for you to accuse a good person of not caring about human life, shame on you. Shame on you.
Mr. Chair, if I could just point out that the safeguards that I mentioned are in the Criminal Code of Canada. That is a legislated safeguard. We also have protections, say for exceptional circumstances, against compelled treatment in this country. That's protected under the Charter. Thank you.
Next up, we have Mr. Johari, please, for 5 minutes. Someone over on the Liberal side, Mr. Nakvi, please, for 5 minutes.
Thank you very much, Chair. I do want to go back to the safeguards, because I think that's a very important conversation to have. So starting with you, Mr. Virani, why don't you outline the legislative safeguards that are in place, and perhaps, Minister Holland, you can then talk about the safeguards that are being put in place through the medical community in order to administer MAID properly.
So let me start with the legislated safeguards that are in legislation called the Criminal Code of Canada. The MAID request must, so we're talking about track 2, which is where death is not reasonably foreseeable. You must make the request in writing. 2 independent doctors or nurse practitioners must provide an assessment. The person must be informed that they can withdraw their request at any time and in any manner. The person must be informed, to Mr. Cooper's point, of available and appropriate means to relieve their suffering, including counseling services, mental health and disability support services, community services, palliative care, and must be offered consultations with professionals who provide those services. The person and the practitioners must have discussed reasonable and available means to relieve the person's suffering and agree that the person has seriously considered those means. This assessment must take at least 90 days. You can posit, and what I've heard anecdotally is that in the context of mental illness as a sole underlying condition, it would likely take much longer than 90 days. And lastly, you must provide final consent immediately before MAID is provided. All of those safeguards are legislated. These are not practice guidelines, practice standards, etc. Those are in the Criminal Code of Canada under the MAID provisions. I'll turn it over to Minister Holland.
So just very quickly, just to cap that part off, so by legislative means, being in criminal code, that they have the full force of law as it relates to the Criminal Code of Canada behind those safeguards.
That is correct.
Thank you. Minister Holland.
Thank you so much. Look, this is, as I get an opportunity to talk with clinicians, doctors, nurses across the country, all of them are, trying to get this right and deeply concerned about their patients. And that's why I get so upset, because I think, as parliamentarians, casting aspersions on people's motives, trying to insinuate that somehow anybody's not caring about human life is just deeply irresponsible. In my experience, those that both develop the national accredited MAID curriculum, those who develop the practice standards, those that are in the system are trying deeply to work with people who are in extraordinary pain. You know, talking to a doctor who has a patient who's been coming to them for decades in unspeakable pain. And that doctor says, I can't do anything for this patient. We've tried everything. And that patient is asking for a way out. It is extraordinarily painful to hear that. And you can have an ideological position that you don't want to deal with that, but I think that understanding that navigating this and trying to work with the provinces and territories so they have appropriate safeguards, looking at CAMH suggestions around clinical guidelines, I think is entirely appropriate, because we do have to make sure that those safeguards are as strong as possible and that we are only dealing with those remote and most unusual of cases.
So it is a very difficult place for us as parliamentarians, of course, to make sure that those who are responsible to administer the system feel confident that they have all the systems in place. And so I believe personally that it is prudent for us to grant this extension so there's no doubt the system across the country with the equity that we want to make sure is available. And I give a fair bit of credence to the letter that you've received that is before us from 7 provinces and 3 territories. And the part that got my attention, which says it is critical that all jurisdictions, health authorities, regulations, and MAID practitioners have sufficient time to implement these safeguards and to address capacity concerns that are expected to result from the expansion of MAID eligibility. The current March 17, 2024 deadline does not provide sufficient time to fully and appropriately prepare all provinces and territories across Canada. How much was that an influence in your decision to bring forward this particular piece of legislation?
Well, certainly it was a significant contributing factor, as I've indicated earlier. I think that, you know, I have a very good working relationship with and talk nearly every day with my provincial and territory counterparts. And so when they say that their system needs more time, I take that very seriously. They put that in a letter to us and have been clear that they want to look at additional safeguards, you know, potentially saying that they want a psychiatrist to be present and involved in every instance, asking again about this issue of clinical guidelines. So, you know, I think that listening to the provinces who are responsible for the administration of those programs is critically important, and certainly it played a significant role in the decision to also listen to the Joint Committee's work.
Thank you very much.
Next, we have Monsieur Thériault pour 2 minutes et demie.
You have 2.5 minutes, sir. Well, indeed, there are the legal safeguards and there are the clinical safeguards. In the regulations that will devolve from the legislation, from the Act, would there be, well, could we put in the Act itself something about Recommendation 10 of the expert panel's report? I think that would be a good idea. I know that what we will eventually carry or pass has nothing to do with that because we aren't at a final enactment yet, but it seems that that would be useful work to carry out. Another matter of relevance when it comes to mental disorders, Recommendation 16 about surveillance review, not retrospective, but looking forward. Quebec has set up a plan to annually report on the application of these approaches. When it comes to mental disorders, we would need a provision that would be foresight, really, before anything took place. Let's say it's admissible, the patient is eligible, they've gone through all the different questions and stages, and then there's a committee at the very end that examines, that reviews the whole procedure to ensure that it's adequate and respects all the safeguards, both legal and clinical. It seems that would be very relevant. It seems an important thing we should do, particularly with regard to mental disorders, given that experts are of differing opinions, and if we want to ensure that the approach is adopted calmly and has social support. As soon as this bill passes, when it comes out of the Senate, what will be the steps we will need to undertake immediately? Because this is the problem we faced since the outset with MAID. You see, we've just waited on this, waited on that, and then there are continuous requests to extend temporary exclusions and so on and so forth. What will we do the day after this legislation receives royal assent so we can move forward? Well, it's not just a matter of working of the Senate passing the legislation and waiting for them to do any work. We're working on a day-to-day basis already with each province and territory to improve the system's capacity to deal with these difficult issues, to hold the conversations that are needed about directives, advanced directives, and so on, and many other aspects, and to continue the training to ensure that we are ready for this eventual change, because it's not going to be an easy one. It's such an emotional topic. Mr. Thériault, your question lasted for over 2 minutes with the answer, and you are out of time. If you have any other thoughts, go ahead. But Mr. Thériault's time is up, I'm afraid. Okay, no, I'm afraid. No, I'm afraid there's no continuing at this point.
Please, for 2.5 minutes.
Thank you, Chair. I want to ask one question of each of you in the 2.5 minutes, so please respect the time that I have. To you first, Minister Varani, I've heard the constitutional arguments thrown on both sides of the equation. As Minister of Justice and the Attorney General of Canada, is there an interest from your department in referring this issue to the Supreme Court of Canada?
The matters of complex social policy are for Parliament to determine and for courts to evaluate after the fact. There is no interest in pursuing a reference right now, and an abstract reference question can even be denied to be answered by the court.
Okay, thank you for answering that. Minister Holland, you know, in my riding at Couch in Malahat Langford, and I understand the differentiation between mental health and mental illness, but, you know, when I go around my riding in particular sections, in particular communities, it's quite obvious that many people are suffering from a mental illness. You can see it right on the streets. I think some of the concerns that have been raised, and I take the point of the legislative safeguards that exist in the criminal code, there still is a very real concern that because of an individual's circumstances, the fact that they may come from a disadvantaged population, they may not have had the same access to services through their life, there's a very real concern that they may still be able to satisfy the legislative safeguards in the criminal code, but they may have been sent down that path because of the life circumstances they find themselves in. So how do you, as Minister of Health, given the great needs that we have and are very evident across our country, how do you resolve that as a minister with such a very sensitive issue?
Well, thank you so much for the question, and I acknowledge that to be true. That you know that often there's a direct correlation between those that have suffered the most and those that are in the worst state of mental health. And sometimes when somebody has a mental illness, which again is different, it can certainly be greatly exacerbated by trauma or by those very difficult circumstances of which you speak. And so one of the reasons why I think we need time is we need to make sure that we get that line exactly right to the point that you're making, that we don't want to wind up in a circumstance where somebody, you know, articulates a desire to, you know, they have a mental illness and they pushed and there was something that we could have done. Like we have to exhaust everything, and it can really only be at the end of the road after we've tried everything and we've been able to find no solution, where, you know, I think we're left with that question, what do we do as a society? If somebody has tried absolutely everything and is at the end of the road in terms of pain and wishes of their own volition then to end that, that's a complicated, difficult question. That's why I think we have to take time. But I acknowledge the circumstances that you're talking about. It's one of the reasons why at the onset I said those conversations with many of those disadvantaged communities, I think are so essential to make sure that they're fully comfortable that the controls are in place and that we're proceeding in the appropriate way.
Thank you, Minister. Thank you, Mr. McGregor. We are almost at exactly 1 hour. I propose one question each from the Conservatives and from the Liberals, and please keep the questions and answers short. It's been a long day for everyone. Over to the Conservatives. One question.
Minister, I want to start with this. I believe that your outburst earlier was inappropriate. And I believe that it was very charged. And I find it, I believe that you owe not only the committee members here an apology, but those that were sitting beside you, if you could see the looks of shock on their face when you had your outburst, an apology.
Please get to the question, Mr. Doherty.
The question I have for you is substance use disorder a mental illness? You going to answer?
First point, I did become emotional, and I apologize for that. I think that it's so terrible. I have never done this, to cast aspersions, and particularly to accuse another member of advocating for death. And not caring about human life. And I think at a certain point we have to draw lines in our discourse. At a certain point we have to say there are boundaries in places that shouldn't go, and that there are things that are inappropriate. And I would suggest that Mr. Cooper making a suggestion that I or any member of Parliament doesn't care about human life or is irresponsible and is something that at some point in time, yes, will elicit an intemperate response.
Okay. Mr. Doherty also asked a question about whether something was a...
Is substance use disorder a mental illness?
If you could just answer that.
I think that, that we have a crisis, absolutely, with substance use in this country, and that substance abuse almost, in many, many instances, has as its root a mental health concern, yes.
Is it a mental illness,
Thank you. Thank you both. The last question over to the Liberals. Mr. Maloney.
Yeah, thank you, Chair. Thank you, both ministers. My question is going to be for Minister Holland. Look, this is an emotionally charged debate. I don't think anybody needs to apologize for demonstrating passion when they're discussing this. I've been involved in this process since very, very early on, along with Mr. McGregor, Mr. Cooper, and others. Look, we're dealing with a very specific issue, and that is whether to postpone the implementation of MAID solely for the purpose of mental illness. We're not here to debate constitutionality. We're not here to debate, advance requests. We can debate the morality. These discussions are going to take place in another context. So my question is this, and I put this to a witness earlier. I feel the only responsible thing I can do as a legislator, and I think people around this table agree with me, is that regardless of what side of the discussion I fall on, if I'm faced with a lack of consensus by professionals, that the only responsible thing I can do is to postpone it until to allow for further discussion. So two parts of my question. That's the first part. Do you agree with me? And the second part is on the timeline. You've introduced a piece of legislation that postpones it for 3 years as opposed to indefinitely. And Minister, you addressed this briefly earlier, but is the reason for doing that not to advance an agenda, but to keep it on the agenda? Because otherwise it can just fall into Never Never Land. Thank you.
I think that's an entirely appropriate way to characterize it. I think that the concern with putting it off indefinitely is that we leave those people, and there's not many, but they're there, who are in intractable, horrifying conditions, trapped in mental torture with no prospect of us moving towards any possible solution. So it creates an imperative to act and an imperative to keep moving. And in 2 years' time, Parliament will get the opportunity once again to conduct a parliamentary review and to evaluate the state of readiness at that time.
Point d'ordre, Monsieur le Président. Point d'ordre.
Oui.
A point of order, Chair. Yes. The bill now before us has been mentioned several times by the Bloc Québécois in an attempt to discuss advance directives. So I don't accept our saying that it can't be discussed here because it has nothing to do with the topic. That is not a point of order, but you've made your point.
First of all, I know that you're aware of this. The motion that sent this that resulted in this meeting taking place indicated that we could have a minister. We had 2 ministers show up. Thank you. This has been I know it's been a long day for you. It's been a tough day for everyone. It's clear how important and how difficult this issue, but it's also clear that that you care deeply about it, and we very much appreciate you being here and working through all of this. Is it the will of the committee to adjourn the meeting? Yes, sir. We're adjourned.